Someone make it make sense.
Probably a couple.
What is up, squirrel people of the world? Y'all, I'm so excited. I'm sorry I had to push back the live stream, but I was getting all this stuff ready. I have another video presentation, so I was exporting that. I'm really excited to go through what we're going to do today. We've got a lot to cover. It's IGG Bonanza, an IGG frenzy, if you will. So welcome, everybody. And if you are new here, welcome. I will have Nightbot put a link in the chat as well for the Discord. I know I mention this every live stream. And also, if you are new here, I will also let y'all know that I do really detailed timestamps for every live stream too. So for anybody who's on replay crew, once the live stream's finished, I get those timestamps done as quickly as possible. So I just wanted to mention that as well. But shout out to Flash Fan. Happy to see you, my friend. Let me know if you need me to remind you what day it is. Or where to find something. Jokes from last night. Okay, so a couple things. First of all, I've been meaning to mention this. Have you guys seen any other people on YouTube where in the chat there's a thing called goal? To my knowledge, it's not every channel has it. It's like a new thing, I guess, that YouTube's been rolling out, so only certain people have it. And I noticed this like, I don't know, maybe a week ago. I was creating a live stream, and I noticed that you can't see it on StreamYard, but you see it on YouTube. So when I was creating the live stream and it had the YouTube thing open, I saw that I have that option. So have you guys seen anybody use that? Is that something that you are interested in utilizing? Let me know. So that was one thing. Next here, let's see. Okay, I also wanted to follow up with something too. So on the last Bryan Kohberger live stream, we had a friend in the chat mention that there was a new filing regarding to LISC, the Rex Heuermann case that had to do with, I guess, IGG or DNA with like a hair or something. And so anyway, I looked into that and I couldn't find the actual filing, but I was able to read what the reporting's on it. You know, I read many of them just because that's the best case scenario if you can't read the actual filing, just to try to get a good idea of what it's about. So essentially what that was about was that that particular type of testing with the hair hadn't been testified to in the court of law in the state of New York. So as soon as I read that, I was like, oh, I know where this is going. Daubert hearing, right? Sure enough, that was what it ended up saying in the articles that I read, that in other words, it doesn't seem like they were in the motion like there was issues with IGG or anything. Essentially, it was just because of the fact that, you know, no one had testified to it, and that's about that particular type of evidence in the state of New York. You know, you have to do that whole, you guys know. So, so that's what I was able to glean from that. Oh, so Flash is trying to obtain some Menendez brothers trial transcripts. That's good. Awesome. Congrats on that, Flash. So, and then the other thing I was going to say, okay, let me look at my list here. So, okay, so, you know, I've mentioned this before, but I'll just reiterate. So, you know, I think it's a good thing for us to, as trial people to strive to, you know, in any case where we're following, you know, pretrial litigation, to strive to wait until trial to, you know, form, if you want to form an opinion onto whether you think someone will be found guilty or not guilty, to wait until trial to, you know, take a really hard stance one way or the other. If you're going to take a stance one way or the other. And, you know, as I've said before, and if ever there's a case where that is maybe the most relevant, I think that would be this case, because we have like so little information, less than we usually have as far as the evidence is concerned. And so with a lot of what's going on here and right now in this case, right? I'm trying to read my handwriting here. Right. We're dealing with things like constitutional rights, we're dealing with things like discovery violations. We're dealing with search warrants and motions to suppress. And we're gearing up towards these hearings on January 23rd and potentially January 24th, dealing with many motions, but among them are the motions to suppress. We're going to talk more about that here in a second. But there was the latest batch of filings that just got posted onto the docket, right? So here's the thing that's crazy, right? Shout out to Just Beth. Happy to see you again. And I appreciate that comment. Thanks for all the factual BK coverage. You're very welcome. I'm happy to do it. I know there's a lot of coverage out there, and we'll just leave it at that. I'm happy to provide factual coverage for sure. Top Cat, welcome again. Had to Google IGG. Well, don't worry. You're going to learn a lot about it. We're going to delve into it. And we're going to take a really good look at how the whole thing works. I've got a really great presentation for you guys with visuals that will lay it out and simplify it. So don't worry. So we're going to start with the documents, and we're going to weave in the presentation. I've got a lot of awesome plans here. So awesome. But happy to see you again, Top Cat. Yes, excellent. Hope everything is well in Australia. So here's the thing though, right? So how often have you guys seen where the defense, right, is wanting to unseal, briefing? So that would be documents, the hearing. They're wanting to make things public related to the IGG, right? Remember, normally you've got, in most cases, right, you've got the defense making motions for protective orders or to have things filed under seal, or they don't want stuff coming out, right? Why? Because they don't want the court of public opinion to come to conclusions before trial, right? In this case, the reason that everything has been under seal as it pertains to the IGG is because in summer of 2023, the state made the first motion for a protective order. What's a protective order? It's, the different states call it different things. It's basically just to seal all the IGG stuff, right? The state made the motion for that, and it was granted, right? And so this has been a long time coming. This is the first effort now, in this case, to say we want to, this is a motion to unseal, okay? And I haven't read this yet because I wanted to do a first look with you guys. I'm really excited. But this is huge. Because the IGG is crucial in this case. And it was used in a very different way than the way it's usually used. And again, for anybody who's not familiar, we're going to get into it and it'll be really simplified for you guys, into the, what matters, right? So, Flash says he's going to go to bed. Yeah, right. You never go to bed. But good luck tomorrow. I know you're going to mod tomorrow, right? Right. So talk. Why isn't it in discovery? Why all the secrecy? Right. So right. The state would say that, like, if I were to summarize their motion for a protective order, right? They had a couple different things. Well, let's summarize. Let's take a look, and we'll just summarize some of the key points from that, because why not? So let me show you guys. Let's jump to this. So here's the docket. There's been a million filings in this case. Let's go to 2023. I can never remember if it's June or July because I always get those 2 months confused because they both start with a J and then the second letter is a U. There's the objection. Hold on. It's here somewhere. Protective order. Hold on. Let's see. Here it is. Okay. I need to just remember the date and then I can, so June 16th. I'll get it confused with July, but anyway, it's all good. Okay. So we'll just go over some of the states because to answer this question, it's a really good way to kind of get into this, right? Why did the state, because if we're going to read a motion to unseal it, right? Let's just review. Why did the state want it sealed in the first place? Great way to do this. Okay, so first thing, the state seeks to protect from disclosure, the names and personal information of the hundreds of innocent relatives on the family tree. Now, that's debatable, but we'll talk about that later. But this is what they're saying, right? So, because normally with IGG, this would be the case. Normally, right? That's important. Normally. And so that kind of would make sense, right? If that was the case here, okay, let's just say this. If it was a different case where it was done normally, then you would have all these relatives on a family tree, and it would make sense that their names shouldn't become public. That would make sense, right? The other thing they're saying is that the disclosure of the information is not required. So one of their key arguments here is not like, here's why it should be sealed. It's like, well, it's not required that we disclose it to the defense. Like initially, never mind being sealed. Let's go back to this. Their first thing was they didn't even want the defense to have it. Let's start there. The state did not want the defense to have this information. Okay. So there's the first fight the defense had was to try to get this information in discovery. And now the second fight that they're fighting now is trying to get it unsealed, some of it, right? Okay. So we've covered this at length, but that's not what we're talking about right now. So we're going to get to what their argument is here. Namely, again, they're relying on the rule that the rule is not going to require them to disclose it. Sad, right? Here, defendant served on the state a request for discovery. Here we go. Like I said, the defense didn't have any of this discovery, right? A request for discovery that calls for the IGG information, even though the IGG information falls outside of Rule 16 without first obtaining an order from the court. The state now seeks, and the court should enter, an order protecting the information, that's the protective order, related to the use of IGG in this case. Specifically, the state seeks to protect the following information: the raw data related to the S&P profile and the underlying laboratory documentation related to the development of the profile, such as chain of custody forms, laboratory standard operating procedures, analyst notes, etc. All information related to IGG. So remember, this is all the information that the state is saying we want to protect it and not even give it to the defense or have it public. All information related to IGG efforts and for creating family tree. Again, we will talk more about that. And then here's what it says the state does not seek to protect, okay? And they will disclose. A genotype kit report, information related to the STR DNA. Now that's the DNA from the knife sheath. That's completely different. It has nothing to do with IGG, right? That's the DNA from the crime scene, right? Yeah, obviously you're going to provide that, right? Jesus. And again, and actually having said that, this first bullet point here as well also has nothing to do with the IGG. Basically what they're saying is the only thing we're not going to withhold from the defense and we're not seeking to protect is like the DNA stuff related to the knife sheath from the crime scene. Okay, great. And there it is. That's their 2 points. The court should grant an order protecting IGG information in this case because the IGG information does not fit into the discrete categories listed in Rule 16, and they want to protect the privacy of the defendant's relatives. There you go. Okay. So that's a rundown on that, right? So that's what's been going on. Okay. So now let's get into this. Are you guys ready? So this was just filed on the 13th, but it just posted. Defendant's motion to unseal the IGG suppression briefing and hearing. And here they are. The related briefs are: 1, memorandum in support for motion to suppress, read genetic information with the exhibits. Sealed objection to defendant's motion to suppress. Reply to state's objection to defendant's motion to suppress, and memorandum in support re genetic information with attached exhibits filed under seal on 12/20. So everything that they've noted here, these are all the recent filings. So like they gave the dates, right? And we've covered all these documents, right? So we've got 11/18, 2024, 12/6, and 12/20. So these, and you know, it makes sense, right? Why? All of these, look at them. They're all related to the motions to suppress, right? And that's what they're going to be arguing, oral argument, right, on January 23rd. So it sounds like what they're wanting to do is have these unsealed so that when they have that hearing on the 23rd, they can argue this. And I think their goal is they want to be able to finally discuss this where the public can hear about it, right? Like in other words, when they have this hearing, all the hearings for the motions to suppress, right? Initially, it seems like, well, we would have maybe heard them argue all of the motions except anything related to IGG because all that's under seal. So they want that unsealed so they can argue all of it, which makes sense, right? They want to be able to argue all of the different motions to suppress out loud in front of everybody to hear, basically. Procedural history. All right, Mr. Kohberger filed his first motion to compel. So is that their only reason? Well, we will see. We will see. That's just a footnote, right? That's just a footnote telling us which briefs they're referencing, right? Because like right here, it just says suppression briefing. It's like that. What is right? You know, they have to be specific. If they want to ask for something, you have to be specific, right? So the footnote, that's what they're referencing. Okay, so procedural history. Mr. Kohberger filed his first motion to compel IGG discovery on June 22nd, 2023. Hi, DB. Hey, by the way, I'm glad to see you again. Were you here at the beginning of the stream? Because I was talking about, I think it was you, right, that mentioned Rex Heuermann with the recent filing. I was talking about that. So I don't know if you heard that, but I think it was you who had brought that up. And I was like, no, I haven't seen it. I'll go look for it, you know? Oh, that was you. Okay, that's what I thought. Yeah, I have a pretty good memory. So yeah, I couldn't find the actual filing. I don't know if you were able to find it, but I couldn't find the actual filing. I tried, but I read a bunch of different articles describing it because, you know, normally I wouldn't read articles describing something. I'd read the actual court document. But the best thing you can do if you don't have the document is read more than one article about it so you can make sure that you're getting good information. But anyway, yeah, I think it sounds like they're asking for a Daubert hearing because, yeah. I don't have Twitter, but Discord is the way, my friend. Discord is the way. But I would love to see the actual filing and then we can go over it. If you want to, you can join the Discord. We'd love to have you there. It's awesome. And you can post links for things there. You can do lots of things, but that you can post links as well. Awesome. Okay. Yeah, cool. Yeah, then in that case, I won't talk about it further. We'll wait until we can get the document and then we'll do that. So, all right. So Mr. Kohberger filed his first motion to compel IGG discovery on June 22nd, 2023. The hearing on that matter was public and involved the testimony of several expert witnesses. The court ordered production of records in camera under seal. Mr. Kohberger filed a second motion to compel IGG discovery on April 15th, 2024. Over the objection of Mr. Kohberger, the court required that portion of the May 30th, 2024 hearing on the second motion to compel IGG discovery be closed. So again, what are they saying? They're saying that, again, the defense did not want it closed. Again, this is not what you typically see. Over objection of the defense, right? They wanted everything to be in open court. The court again ordered the production of records under seal. The court's concerns were the privacy rights of the names of the individuals identified in Mr. Kohberger's family tree. At the first and second motion to compel IGG discovery, Mr. Kohberger argued that he would be filing a motion to suppress the IGG. He asked the court to allow the pleadings and hearing be public. On May 20th, 24, the court indicated it would take the matter up after the suppression pleadings were filed. And that has happened, right? We've covered all those. In the interim, venue changed, and the case is now before a new judge. The motion to suppress read genetic information was filed on November 14th, 2024, and is now fully briefed. Pursuant to court direction, the parties stipulated to file all IGG suppression pleadings under seal. No names of the extended family tree are discussed in the briefing. So I am really glad now that we just went and did a little recap of the initial motion. Why? Because remember, the state had two reasons for that motion. One of them is names of family tree. Look, no names of the extended family tree are discussed in the briefing. So that's why they're pointing that out, right? Excellent. The matter is set for hearing on, there it is, January 23rd and January 24th, 2025. Mr. Kohberger requests that the briefing be unsealed and the hearing take place in open court. So yeah, so that's what I was speculating to early at the beginning of this filing, right? They want the public to hear this information. That's why. That's what they want. Hi, IS, glad you're here. Also, shout out to Need Some Z's. Yep. And we're going to, y'all, I'm really excited. I've got a great presentation for you guys. So yes, the investigate in quotes. Yes, 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 yes. Just wait. Okay. So, I just got goosebumps because like, I'm really excited to show you guys what I have lined up there. So, okay. So argument, due to national and international attention to this case, and in the interest of protecting Mr. Kohberger's right to a fair trial, many pleadings in this case have been sealed appropriately pursuant to ICAR 32. ICAR, which is Idaho Court Administrative Rule, right? Mr. Kohberger has a right to a public trial, and sealing a suppression hearing is a clear violation of his right to a public trial. In addition to Mr. Kohberger's right to public trial, the public has a First Amendment right to know what goes on in its courts. Idaho Code, blah, blah, recognizes that records contained in court files of judicial proceedings may be exempt from disclosure under rules promulgated by the Idaho Supreme Court. The Idaho Supreme Court adopted, there it is again, ICAR 32 to define when public access to judicial records may be denied. When the court is considering whether to seal the record, Rule 32I directs the court to consider the traditional legal concepts in the law of the right to a fair trial, invasion of privacy, defamation, and invasion of proprietary business records, as well as common sense respect for shielding highly intimate material about persons. Okay. Under Rule 32IL, records may be sealed or redacted if the court determines and makes a finding of fact as to whether the interest in privacy or public disclosure predominates. So it's kind of like, you know, when we talk about, you know, they have to weigh prejudicial versus probative, kind of similar here. It's like weighing, you know, interest in privacy versus the right to public disclosure, right? You have to weigh it. The court weighs it out, and then the judge gets to just decide. The court's decision to seal judiciary. Yeah. Keep reading, Chelsea. To seal judicial records is discretionary, right? It's in the discretion of the court. Here, the way in which the IGG material was accessed and used is a matter, there it is, y'all, right here. Let me read this again. Well, I didn't even fully read it. Here, the way in which the IGG material was accessed and used is a matter warranting public disclosure and should not be shielded from public's right to know. This matter is of utmost importance to Mr. Kohberger's right to a public hearing. Holding the hearing in open court will not prejudice the parties, and this should be held in open court. And again, right, we've got, in this case, we have the state wanting everything to be hidden, and we have the defense wanting everything to be open, transparent. The issues raised are legal issues, and cases with similar issues are being decided in other states. The issues raised in Mr. Kohberger's suppression motion are those that were discussed in the public hearing on the first motion to compel. And there's a footnote here. Aspects of the IGG investigation in this case have already been leaked. Let me click. I think we've already covered this, but let me see what happens if I click on this. Will it open? Let's see what happens. Let's see. Have we already read this? Probably. When was this from? Actually, let's see. January 10th, 2023. Wow. Okay. So like right after, I mean, wow. Okay. Right after the affidavit was released. Well, yeah, right. It says a key reason police focused on Kohberger as a likely suspect has to do with something that is never mentioned in the 18-page affidavit. Forensic genealogy. Yep. Yep. This article right here is discussing literally what we've been doing, which is Elantra versus the DNA and the IGG, right? The two different timelines, and we're gonna, again, we'll talk more about that. The precise way forensic right? Again, the precise way forensic genealogy helped investigators zero in on Kohberger hasn't been previously reported. We're going to talk more about that too. What I'm looking for, though, is what they said about how details of the investigation were leaked through this article. I'm just looking to see what they're referencing specifically with that. Right. The Idaho affidavit's thoughtful omission of any reference to genealogy. Gag order. On December 23rd, 3 weeks after Kohberger's Elantra first made the list, Payne applied for a search warrant for records of Kohberger's phone activity. The results helped to convince Payne that Kohberger was the Elantra owner he was looking for after all. Yeah. So the question is, what happened shortly before Christmas that refocused Payne's attention on this particular Elantra owner? The answer, according to the source familiar with the investigation, is partly that the officer got back the results from a forensic genealogy team. What does this mean? This is exactly what we've been talking about with the timeline, right? What does this mean? It means that the way they got to him was not the Elantra. It was IGG, basically. IGG, not IGG, but we'll talk more about it. Let's just see. This is probably what the defense was referencing right here. This is the Othram part, right? Idaho State Police has a contract with Othram. Yep. Still, even after pulling the phone records, the team had no way to be certain Kohberger's DNA would match the knife sheath DNA. A genetic genealogy lead is just a hypothesis, after all. A final step typically involves conducting surveillance on the suspect and then collecting something they've discarded, such as a cigarette butt or soda can. Dad trash. And there it is, right? There's the dad trash. Yep. Okay. This is great. Okay. Some suggested that the absence of any reference to forensic genealogy meant that it had not been utilized after all. But there is another explanation. Forensic genealogy leaders at the FBI and beyond have directed police departments to omit all references to the technique. Numerous people involved in the investigations have told me. The only reason it would show up in a probable cause document or search warrant these days is if a police department rejected their guidance. As to whether keeping out of court documents is a problem, two primary camps have emerged over the past few days. So much of this is getting to what we're going to go into more. Right. Wow. So this is just how people this is just how people can argue both reasons to keep it out or why it should be let in. One strange consequence of the current policy is that even Kohberger's relatives may never know, blah, blah. Okay, that's the end of the article. Okay, so now that was a little tangent because of the footnote. So now let's go back to where we were. So the thing is, this is a renewed frontier, right? It's really, it's been used in other cases, but this is really a case of first impression, and that they've said as much. Like the judges have said as much. Like it's even in some of these documents, at least for Idaho. But really, like part of the problem too, when I say at least for Idaho, I'm like, part of the problem too is the Supreme Court. None of this has made it to the Supreme Court yet, right? So the Supreme Court has not had a case come before it, or at least that one that's been ruled on yet, right? A decision being made that deals with this. Like it's basically a lawless territory right now, right? With IGG. And so that's part of the issue. And when it comes to how what can happen, right? In terms of how can IGG be used, what are the protocols? There's two pathways, right? One would be legislation, right? Where either the federal government, right, would have to, I mean, that would take for fucking ever, or states, right? And to that end, there's specific states have the ability, and Maryland is one. Maryland is the exception. Maryland is the state that has actually put into their state legislation rules about how you can use IGG. But they're the only one. There's, I think Montana has like a couple things, but it's minimal. So, but Maryland's leading the way on that. Okay. So the states can do that, right? The other thing is case law, right? Where once there's a precedent, right? So in other words, once it's a matter of when, right? Once a case makes it to the Supreme Court that deals with IGG and they make a decision, that is mandatory and binding for every court at every level of court level in the whole country, right? You're going to follow that if it's U.S. Supreme Court case law. The other thing that can happen is then that you have your state Supreme Court case law. So for example, pick a state, any state, North Carolina or Idaho. Once something makes it to the state Supreme Court, then that could be binding on other cases in that state. But the thing is that neither of those have happened. It's not made it to the Supreme Court, and it's not made it to the Idaho state Supreme Court. So hopefully that makes sense. Absolutely. Top Cat is saying, very astute. The law hasn't caught up with the technology. The law is always behind, and it takes forever. But yes, times a million. That is an understatement. It is way behind. It's way behind. Yep. Yes. And that's why this matters, right? This case matters for a lot of reasons, but it's some of those reasons are bigger than just the case itself, right? This could be the case, right? That makes it to the U.S. Supreme Court. It could be. So yeah. So, okay. So there's that footnote. All right. Additionally, the way in which IGG occurred in this case has been made public in other cases. Okay, conclusion. Mr. Kohberger has a right to public trial. Yes, indeed. Okay, good, great. So now we're gonna move right through these next documents, and then we're gonna get into the presentation. So, okay. Okay, so the next thing we have, so just to follow up with, the defense previously had made a motion to have to exceed a page limit, right? And what was that for? Oh, guess what? It was for this, right? The reply to the state's objection to the motion to suppress genetic information, right? They wanted to exceed the 10-page limit. That's been granted. Okay, great. Next one. And Judge Hippler is making good on his, promise. Like, as long as you ask me ahead of time, right? Like, you can have longer time, you can have more pages, you just have to ask, right? So they did it. It's all good. All right. Now, I have been waiting. You guys have heard me say, I'm so excited for the witness list, right? I'm so excited for the witness. Well, yeah. Order sealing defendant's witness list and exhibit list for the motions hearing on January 23rd and potentially the 24th. It's all under seal. So that's following up on that one. Did I say shout out to Blackwater? If I haven't already, shout out to Blackwater and Ireland. Okay, so like I said, we're moving through these, right? I wasn't kidding. So now, this is interesting, isn't it? Order sealing state's amended expert disclosure Lawrence Mowery, good old Mowery. Based upon the state's stipulated motion to seal state's amended expert disclosure Lawrence Mowery and all attached exhibits filed herein and no objection from the defense, the court does hereby confirm and order that the state's amended expert disclosure Lawrence Mowery and all attached exhibits are exempt from disclosure and sealed for the reasons stated in the motion. Okay. Next. And this is the last one of the documents that are not sealed, right? That just came out. So, okay. And this is the thing that makes me upset. This hearing that we've all been very excited for, right? So, okay. So notice of hearing and order regarding January 21st, right? So we know that the date we've all been gearing up for, right, is January 23rd. So on January 21st, the court will hold a closed sealed hearing by remote video to hear the defense motion to unseal materials related to its request to support. So this is the motion that we just read, right? The defense motion to unseal. So they filed that. And then in response, the judge said, well, now we're going to have a closed hearing to talk about. And why, right? Because remember, they want to be able to use this information on the 23rd. So 2 days before, right, they're going to have a closed hearing to talk about whether or not he's going to grant this, right? So in other words, on the 21st, we will find out the answer to, will they unseal this, right? Because it'll come up on the docket. But here's the part. Now, number 2 here. What portions, if any, and under what circumstances should the various motions set to be heard on January 23rd and 24th be open to the public, either live and or by video? And I think everybody that's following this case has been assuming that they're going to be public. These suppression hearings need to be public. This floored me. I couldn't even believe this was in here. Like, what? Why are we even asking this question? I mean, my assumption was like anything regarding IGG, of course, is sealed. Like that's where we've been. That's where we've been is if it's IGG related, it's going to be sealed. But if it's not, it's going to be public, right? Whether it be documents, whether it be hearings, that's what I kind of figured, right? So the reason this is crazy to me is because there's all those other motions that don't deal, they reference IGG, but they're not, again, all the documents, the motions to suppress, Apple and Google and all the others that we covered, right? Like there's a bunch of them. Those were all public, I figured it never even crossed my mind that the oral argument on those motions would be closed. It just doesn't, I can't even fathom that. Like that doesn't seem, oh God. Okay. So the way I will weep if he's like, this is all going to be closed. Like that will be a problem for a lot of people, I think. So what would I like to see happen here? What I would like to see happen is fine, have your closed hearing, right? Because you have to talk about it. Fine. But what I would like to see happen is granting the defense's motion to unseal, right? The materials related to IGG as listed in that footnote from before. And then therefore, if they are able to do that, if that is granted, what that would mean is then that would potentially mean, and this is what I would like to see, that all of the hearings on the 23rd and 24th where they're arguing these motions to suppress would be open, right? And we would be able to hear them argue over the IGG. So the thing that still hasn't been brought up in these filings recently is anything regarding the Franks motion, right? Like the judge still hasn't ruled on that, actually. And I think that he's just handling that potentially separate, right? Like from like the motions to suppress is like all one thing, and then like maybe the Franks is going to be after, but like there's not been any mention of that in these recent filings. You know, the last thing was like the defense made the motion for a Franks hearing, right? And then the state objected, and then you know, they got in trouble because they weren't specific enough with their exhibit, you know, page numbers or whatever. So Judge Hippler was like, hey, just make sure you're specific so I know where to look for things. And then they said, okay. And like, then we never got an answer if that's granted or not. There's not been, you know, so, okay. So Top Cat asking a great question. Wouldn't all the names be public then, or is that separate? So twofold, right? So to answer that question, here, again, this is the defense's motion. I think that's why what they said, where is it? So remember the briefings that are referenced, where are they? The briefings that are referenced here, okay, that they want unsealed. In those briefings, right, no names of the extended family tree are discussed, is what they said. So that is a non-issue, basically, right? That's one thing. Now, the second thing, and this is a great segue into the presentation I have. The second thing is, why are there no names mentioned? Like, there's two potential things, right? Maybe there is an extended family tree with names in something, right? But if that's the case, what the defense is saying is that in the briefings that they want unsealed, none of those have names, okay? So that means that it should be allowed, okay? But the other thing is, like, maybe, like, what if there's not an extended family tree with a bunch of names? Like, what if the reason that this is the case is because there isn't, right? Maybe that, like, now, remember, why am I saying that? Well, the state has, like, as it pertains to all the IG stuff, the state used this as their main thing, right? We want to protect the names. We want the extended family tree. And the state has made much ado about the you know, the extended family tree. And we've heard about it a ton. And we've talked about it a ton, right? And why am I saying all of this? Well, again, this is a good segue into the video presentation I have, because I have questions about this so-called family tree. So with that, all right, let's jump into this presentation I have. So this is like the IGG tree part 2. So what I've done is I've now incorporated, I had a bunch after the last live stream. I had a lot of more thoughts, okay? And I was like, oh my God, I had some light bulb moments, right? Doing timestamps, which happens every time. But I also wanted to integrate the testimony from Gabriel Vargas from the hearing in August of 2023. So I have taken key parts of that testimony and I've got it interwoven with some visual aids. You guys will see. So, okay, here we go. So for anyone who didn't see this initially, I'll just pause real quick before she starts talking. So this lady, Gabriel Vargas, is like basically the reason why anybody is doing any of this IGG. Like, you know, again, we're using clips from this hearing of her explaining how this process works with law enforcement. And you guys, if you haven't seen this, will be shocked at some of the things she says. But her background in terms of like that, we're not going to watch because we've already covered it. Like, but just to summarize, she's the one who found, like, she's the pioneer, right? She's the one who figured this out because it started as a hobby, right? And like now it's a thing where you can actually try to go get certified and all this. And she paved the way for all that. So she's like the expert on how all of this works. And so, in other words, I'm saying that so that everything that she says, right, is extremely, like, if we're thinking, okay, witness credibility, right? That's what I'm getting at. She has all of the witness credibility. That's what I'm saying. She is the expert. So
law enforcement will contact me and say they have a case that they are unable to solve, and they would like.
Okay, so first of all, I don't know why the subtitles are weird, but that's just what it is. So like they're up really high. But the question that was asked to her is like, so what happens? Like if law enforcement contacts you to help with a case, what happens? Like what are the steps? Take me through the steps.
A case that they are unable to solve and they would like to, they like my services. I first evaluate what type of case is it, and are there any, what is the DNA that is involved? Once we establish that and they agree to take, have me take on the case, I have them set up to ship the sample, whether it be something that needs to be extracted to the lab that does that, or DNA that's already been extracted that needs to be sequenced. The law enforcement agency will then send that to a third-party forensic lab. At that point, when the lab receives the sample, I essentially take over the case until I provide the genetic lead back to, or the investigative lead back to the agency. So I keep them kind of abreast as to what's going on, but essentially the case is mine. It's in my control until I am done.
So that's important, right? Terrible pause, but that's important, right? So she's saying when I do it, right? But this would be true for, her or someone else who's doing what doing IGG, because she trained everybody. I mean, so essentially it's like when they take over the case, when they're doing the IGG, it becomes, they're the ones that are working this. And part of the reason is because, remember, usually when IGG is used, it's because they've exhausted all other possibilities and they are at a standstill, right? They have no leads. They have no suspect. Law enforcement is stuck. Usually, again, there's a lot of exceptions with this case that make it different, but that's usually the case, right? And that's why it's been so useful for cold cases, right? But that's usually what you've got, right? They are stuck. So they don't have anything more they can do. So they say, we need IGG's help. So they start working on the case. It becomes their case. Now, again, what's interesting here, and we're going to take a look at the timeline is going to be included, don't worry. But like almost immediately after the homicides, right? In this case, homicides, knife sheath DNA, immediately, they go and ask for help, from a private lab, likely Othram, right? From what we know, to do IGG, quote unquote. Like that's important, right? IGG, quote unquote, right? And we'll talk about why I'm saying IGG, quote unquote, because I think it matters. But yes, but that's odd, right? So, okay.
During those communications with law enforcement, do you take their direction? And if they say stop working, you stop working?
Absolutely.
Okay, that question matters. Let me play that again. So, because it's hard to hear, right? Ann Taylor is saying, well, if you're working, this is now your case, right? Right. So she's doing it. But if they say stop working, do you stop working? And that question probably wouldn't have seemed like, why does that matter at the time? But that your guys are going to see why I'm highlighting this, right? Because Ann Taylor asked that question for a reason.
Their direction, and if they say stop working, you stop working?
Absolutely.
Okay. So this is from one of the recent filings, this is from the state's motion for protective order, actually. Okay. In this case, investigators used IGG to begin the process of developing a lead, right? Idaho State Police utilized a private laboratory to develop an S&P profile from the DNA on the knife sheath. The private laboratory started using genetic genealogy to develop a family tree. Started, right? But after law enforcement decided the FBI would take over, the private laboratory ceased its efforts and sent the profile to the FBI. So there you go, right? They started it, and then they were asked to stop, and the FBI is going to take over. There it is again, right? So I just to highlight here, right, it says partial family tree. Now, again, like we just mentioned a few minutes ago, there's been much ado about the list, the hundreds, to quote from Prosecutor Santa, right? The hundreds of relatives, the hundreds of innocent relatives, he said, right? In the motion for protective order, hundreds of innocent relatives. Boy, that sounds like a huge ass family tree, right? And also, well, we'll talk more about it, but imagine the time it would take to create such a thing, right? How much time it would take. So what we know here, right, is like, according to this, they're saying essentially a partial family tree. Now, what's interesting is this is partial family tree is kind of like subjective, right? Like, is that one name, right? Did you generate one name and then that's a partial family tree? A partial family tree created by the private lab. So what this would mean then, right, is like the rest of the huge ass family tree, the hundreds of innocent relatives would have had to have come, according to the state, right, from the FBI. Now, why am I mentioning that? Because there's a problem with that, right? And we're going to hear about that more. Okay, so this is the, as I call it, the IGG tree. This is from the state's reply to the defense's objection to the state's motion for protective order, right? We looked at this on the last live stream, but we're going to utilize it again. So, because this is crazy. So, you know, again, we don't know a lot of things, but among the things we don't know, when the extraction was finished, when the DNA was sent to private lab. But again, like I said, what's unusual is like right off the bat, first thing. So at the bottom, you've got K-bar knife sheath, right? The DNA is extracted from the K-bar knife sheath. First thing, send it to Othram, right? And why do you send things to Othram? For IGG, that's what they do. SNP profile create. Like the only reason you even do a SNP is only used for IGG, right? If you look on the right, everything that isn't IGG when it comes to DNA is STR, right? On the right-hand side, it's all STR. So the only reason you would even generate an SNP profile is for IGG, right? So SNP profile created by private lab. And then we have SNP profile submitted to genealogical databases, right? And then genealogical research initially started by private lab, right? And again, the search results would have had to have, from the search results from the database, right? They put the DNA into the databases. The search results would have had to occur on or before November 29th because of the Othram invoice. Local law enforcement then decided the FBI would take over. Why? Again, we'll talk more about it. Further genealogical research would have occurred between November 29th and December 19th by the FBI. Okay.
Law enforcement cases, however, are only permitted to be uploaded into Family Tree DNA and to GEDmatch for a fee. GEDmatch, however, is not a direct-to-consumer testing site. It is only a database where people take their test results from the company in which they tested and upload this site to the site to get more matches, essentially, or higher, closer relatives, higher matches.
Does law enforcement have access to all of GEDmatch?
If properly uploaded, there's a fee that you must pay. You must upload through a separate database than the one in which consumers upload through. You must pay a fee, and you, depending on the case, may be limited on the matches that you are able to see.
Why is that?
The terms of service have changed several times since the Golden State Killer case came out, and which investigative genetic genealogy became very popular. It used to have everyone opted in, then GEDmatch opted everybody out, and you had to choose to opt into law enforcement match as a consumer. It's going to ask you, do you consent to law enforcement matching. And if you hit no, and I am working violent crime non-DOE case, I should not be able to see that you are a match to my unknown DNA contributor.
Right.
You said should not.
Should not.
Does it happen anyway?
You can see how, I'm back up, how tentative, not how, what's the right word? How hesitant she is to answer this question, because this is a big deal. This is going to get into the back doors and the loopholes that are utilized by law enforcement. Okay. And we know that the FBI like showed up at her house, right? Like, I think it was before this hearing. So
You said should not.
Should not.
Does it happen anyway?
It does. It has.
And is that because there's a problem with GetMatch? It's just if you upload it and all of a sudden these things that shouldn't happen did?
it was after. Thanks, Heather. I just in time.
There are a lot of tools that are available in GetMatch. Once you run their matches, there is a tool that allows you to edit that list of matches. When you edit the kit list, if you put the subject's kit number into this tool that you're going to now analyze, these matches, it tricks the system and allows you to see matches that you wouldn't have seen when you ran your initial match list.
And those can be people that did not agree with law enforcement to see their DNA.
Those matches that are revealed are only matches that have been opted out.
And so that's a way to use the tool to get past what law enforcement is supposed to do.
I struggle with this. I'm sorry.
I feel for her.
It is a tool that is provided in the database that essentially allows you to see things that you're not supposed to see.
And so the reason too why we started at the beginning of her thing was like, what were you asked to do? Like the defense in this case just simply asked her like she doesn't have any of the information, right? Because the reason that this hearing even happened was because the defense, remember, at this point in time, they were still fighting to get information. They didn't have any of the information. These hearings with the IGG back in August of 2023 were to bring in experts to make the case. We need the information, right? And but they didn't have it. So she's just basically saying like, how the whole process works, right? And so that's why we kind of start like the defense brought her in not to look at, had nothing to do with, because they didn't have it, couldn't look at anything done in this case, but just like brought her in to say like, teach us everything, basically, right? And why it's important, right? And so Heather also just August 18th. I thought it was the 18th, but I didn't want to say it because I couldn't remember for sure. Thank you, Heather. And also had verified that it was after this hearing that they showed up at her house. And right here. I mean, and this is exactly what I think is we're going to be showing with all this, right? With this presentation, that they're trying to hide that they access genetic info that was opted out. So the whole thing about opted out that she was saying, right? Like what she's saying, right, is like that this loophole. So for people who upload their DNA, right, and they opt out, opting out again, meaning you don't want to allow your DNA to be used by law enforcement because it's you have that choice. That this loophole allows them to see only the people who have opted out. And we're going to hear about more loopholes. This is not the only one, but this is like a huge one, right? And so right, so again, they're 100% trying to hide the access to genetic info that was either opted out of sharing with law enforcement or that they submitted it to a database that's for public use only. Yep. And so the hearing was on a Friday, and then they showed up at her house on the weekend before Monday. Right. Yeah, thanks, Heather. Okay.
And as a result of seeing those things, you're then using that match to find to identify your subject. So you're violating the terms of service by seeing these matches. Another instance is uploading the data as if you were a consumer.
So this is the other big major loophole. There was some other testimony, I didn't include it, but just where they kind of get around fees or whatever, which that, fine. But like, this is the other one that to me is the biggest one. And that, let's listen to her and then I'll say something.
Bypass the fees that you're supposed to pay to Family Tree DNA or a law enforcement kit, whereas a consumer it's free. And you also get full access to the database, including matches that have opted out.
So that makes total complete like that. So, okay. So this is what I was gonna say, because again, I've actually done this. I submitted my DNA to MyHeritage. I think it was before this case even. I think it was before the murders. It was a while ago. It was like more than 2 years ago, probably. So I've been through this entire process firsthand, right? So if you're a consumer, right, and you want to try to build your own family tree, the whole thing about opting in or opting out, that only applies to law enforcement, right? So if you're a consumer using the database, the whole point is that, you're going to be seeing your matches with other people who've used it. So the opting in, opting out is not even a thing. Everybody's opted in right at that point, right? So if law enforcement just doesn't use the law enforcement kit, that's why there's a law enforcement kit, right? Because the law enforcement kit is supposed to only show them the matches that have said, hey, we're opting in for you, allowing you to see it. But if they use it as a consumer and the website thinks they're a consumer, it's going to do for them exactly what it did for me and everybody else. Now, I didn't do the whole family tree thing. I just wanted to see my ethnic makeup or whatever, because my brother had texted me out of the blue and was like, hey, I just did a DNA test and turns out like we have Russian heritage. And I was like, thought he was joking. So anyway, so that isn't, so that's insane. That's not even a loophole. That's not even a backdoor. That's not even a tricking the system. Like we heard about the trick in the system with GEDmatch, right? That's just being dishonest. Like, in other words, they could still be doing that and probably are, right? They just, pretend they just don't say they're law enforcement. They just, upload things as a consumer. You know what I mean? So that's huge as well. So no. So Top Cat's asking a good question. If the FBI gets a warrant to access it, wouldn't it override the opt-out? No. These are all people that are innocent. You know what I mean? These are just anybody, right? There's probably billions of people that have submitted their DNA. Like, it's their right. That's a constitutional right to privacy. It would be sort of like the same as, let's just say that, any of you guys, right? You're just like going about your life, right? Law enforcement can't just come in and search your house, right? And it is like a fourth, I think it would fall under that, right? Because technically getting access to somebody's DNA information or whatever would fall under like search and seizure. And so, and they would have no way to get that warrant, right? Because you haven't done anything wrong. So I don't know if that answers the question, but right, they have to have probable cause to obtain the warrant in the first place. So and yes, this is how they identified him. He was not under investigation this time, right? And the reason that matters, right? Why was he not under investigation? Because they didn't know who did it, right? Remember, and we're going to see it again, but the timeline I was showing you guys a second ago with the chart, like how it was immediate, right? Immediately after the homicides, they get the DNA from the knife sheath, they get a return on that, the initial profile, and the first thing they send it to Othram. So they don't have any clue of anything, right? Okay. But we're going to take another look at it. Don't worry. So that's, yeah. And they to identify, right. So the point here is how did they get to him, right? Like, because the reason it matters, right, is because the state has, the state, the state and all the law enforcement officers, right? Everybody that is working for the state has been working really hard to say that this wasn't how they got to him, right? That it was just a lead, but it'll be really clear when we look again in a minute here at the calendar and the timeline, because it's like they wanted to almost pretend they were working the case, and that's where the Elantra comes in. We found him through, that's where the whole nonsense about finding him through the Elantra comes in, right? Like, if that makes sense. And again, it'll be more clear when we get to the timeline part, but they really had tried to keep this out of it, right? They tried to keep this out because they didn't use the letters like in the affidavit, right? The letters IGG are not said, but it's like plausible deniability because they talk about it. They just don't use the letters IGG. And I've talked about this on their live streams, right? So that's the first way they try to dance around it and keep it out. Then once it's figured out, hey, that's definitely IGG, right? Then what do they do? Oh, they don't want to turn over the discovery. Then when there's motions to compel, what do they do? Protective order, right? I mean, and it's still being fought over right now. That's like, this is why this is so pertinent, because the defense, we just got that motion from the defense to unseal the IGG briefings and stuff, right? So they didn't want it to come in at all. And then when it was like, this is a thing that happened, then they don't want the defense to find out about it. And then they don't want the public to find out about it, right? Oh, glad you're here. Happy to see you again, Gwen. So asking a good question, topic that they had phone pings in a video of his car. Is that wrong? So they have cell phone pings and they have videos of a car. But the state has even admitted I forget, Heather will know which hearing it was. The state has even admitted that they, in any of those videos of the car, none of those videos, they can't say it's him. Like, in other words, none of the videos show the license plate and none of the videos show the driver. And like, it's just the white Elantra. So the only way that they could try to prove, and this is what will come up at, the only way that the state would attempt to prove that is definitely his car would be to tie the fact that the car's movement matches the cell phone movement, and the cell phone is known to be his, if that makes sense. That's where the cell phone pings and the car are kind of, they're definitely related in that sense. But my point is like, sometimes in other cases, right, you might have the car, but you can see the person driving it, right? Or in other words, it's not up for debate. That's the person driving the car. That's their car. In this case, they don't have that. So they would need another way to try to prove that it is definitely his car. And the whole thing about changing of the years, we talked about that a little bit on the last live stream, but we're going to get to that again. That's on the calendar. We're going to take a look at here in a sec. Right. And then as far as the cell phone pings, right, that's one of those things that is at every trial, it always comes out and cross the truth, right? As to, because again, this was a big thing in Murdaugh too, right? Like, a great example of Murdaugh, right? When people in the family were known to be at their house, like that, like I'm not even talking about during the homicides. I'm talking about like whenever. So it's not even disputed. Like people were home, right? Let's just say Maggie's home, say, right? Like there were times where it would be showing her cell phone pings, and there's 3 towers in that area. And there's a tower that's really close to the house, but there's also a tower in Varnville, which is like 25 minutes away. And there were times where the people, like say again, Maggie, for example, was like at the house using her phone, and it was pinging the Varnville tower. So for example, the way it works is it's not, so in other words, there's wiggle room there, right? In terms of proving somebody's location for sure, because sometimes it might use the closest tower, sometimes it might not use the closest tower. And there's a lot of variables with that. So, so again, that's why this comment is helpful, right? It services the area, right? But it's not going to be, you can't pinpoint someone exactly. Now, when it comes to pinpointing someone's location exactly, what I've learned from trials, right? That Murdaugh is a great trial for getting a lot of really good information about how this works. But my understanding, and well, what they said in the trial, right? And I believe these experts, right? They knew what they were talking about. But anyway, the iPhone cache, right? The iPhone cache data, like the iPhone GPS data, like location data, is the most accurate that we have at this point. Well, at the time of the trial, I don't know if there's anything more accurate now, but in other words, I think it's within like 7 feet, right? Because it actually gives latitude and longitude points, right? Like in that beautiful timeline that we had there. Well, let's just pull that up real quick. Let's take a quick look, see here. Let me see if I have that. Well, I know I have it somewhere. Because I'll show you guys. This will be a good way to answer this question, and you will see the difference here. But the iCloud will give you latitude and longitude points. The other thing that can do that, right, is a GPS, like in the car, like in the telemetry of a car, right? But as far as a cell phone is concerned, towers are not the best source. And of course, the thing is too, right? The iCloud cache is only going to pertain, I think if you have an iPhone. I've never had an Android, so Android people, let me know. I could be wrong. Maybe you can still use iCloud, but I don't know. I don't know if it would be built in the way it is on an iPhone. So okay, so let me just find this. Give me just a sec. Hang on. Let's see here. Where? I know it's going to be, it's probably right under my nose. Where the heck? Well, oh, I just saw, where did it go? No, that's not it. Okay. Anyway, whenever I'm playing the more of this video, I'll see if I can look for it further. So, because I know it is somewhere. But yes, let me see what you guys are saying in the chat. Oh no, I found it. Found it. Okay. Let me share this. Hold on. You guys are going to love it. For anyone who hasn't seen this, this is beautiful. It's a work of art. Literally, it is the most magnificent freaking timeline. This is a masterpiece, you guys. So I'm glad we're taking to see this because I haven't looked at it in a while. I just have to unshare, reshare real quick. Here. All right. So beautiful. Look at this reference guide. So they have a full timeline, and this is the way it's done, right? You pinpointing where the person is, where the phone is, where the vehicle is, and when. All three, right? So it's going to show here. Let me find one of the good pictures that has more pinpoints. Here we go. Here's a good example. Let me zoom in. Okay. So on this map, right? So all of those red dots, that's plotting these GPS points. When you look at these GPS points, those are all latitude and longitude. So this is from the car, but wait till, well, let me get to where we have the phone part. Actually, let's scroll better. Aha, okay. So cell towers, guys, cell towers. Here we go. All right. So right here, where you've got these little, I don't even know what you call them, lines with little half circles, right? Those are the wedges that you'll hear people talk about in trials when they're testifying about how this all works, of like the different sides of a tower, right? So these are two different towers, right? And so this is showing the date and the times when calls were made and which tower was utilized to make those calls. I think that was Maggie's phone. Not that it matters, but and again, there you go. You can see the different towers, the different times calls were made. So like that's what you would get from a tower, right? Is like you would essentially, right? Like if you don't have the GPS data, like the iPhone GPS location data, right? What you get is that they're in the area because they pinged off of this tower. But like here's the thing that matters. And this is really relevant because the number of towers matters, right? Like for example, okay, if you look at this map, right? This is a huge ass area. There's only 2 towers. So like literally if you ping off one of these towers, like you could be anywhere, like basically, right? Like it doesn't actually narrow it down. Now in a place like in a big city where they have a lot of towers, it's completely different, right? Because there's so many more towers, you can narrow it down. But in a more rural area, guys, where there's fewer towers, the wider the area that is being serviced by those towers. So it means they could be anywhere within whatever the range is, you know? So, so that's really going to come up. Like as soon as this whole thing happened with these murders, right? And they started talking about cell phone data. I think I might have actually been covering the Murdaugh trial gavel at that time. But the first thing I thought of was, before anyone even knew anything about, before anything was even said, like the first thing I thought of was, oh my God, I already know they're going to have a hard time with this because of the fact that there's got to be very few towers out there. And that it's, I mean, I don't know which one would be considered more remote between Murdaugh territory, right? You know, low country, South Carolina and Moscow. But both of them are, you know, that's a challenge. Okay. So, but now, let's see. I need to get to the part where they show Paul because that's where it's crazy. Aha, this is what I wanted to find. Okay. So like this is so when we get to Paul, so here's the thing. So Paul always had the iPhone location data on. This is the most specific that, like I said earlier, that they can track someone's location, whether they're in a car or not, If it's the phone is with the person, right? They can track the person because the phone. So literally every couple feet, it's like redoing the data, right? So they have all these different plot points and it gives, let me zoom in more. This is what I'm saying. It gives the latitude and longitude point. So versus a cell tower, general area, latitude and longitude point, literally you're standing there. Like that is as specific as it can possibly get. Yeah, look at this. This is a great example. So the iPhone location data, so 814, 819, 823, 824. So this is every time the phone is automatically doing this. How frequently it's even if the location hasn't changed, it's going to keep pinging itself or whatever it does, right? And determining, right? So they have all these plot points. And so he's basically not really moved. Anyway, do you see what I mean though? Like this is beautiful, but you have to have your location services on. But the thing is like certain apps, right? Just to reiterate, this is relevant for trials these days. Certain apps that people use without, they may not even realize it, but certain apps may ask you for your location and you click yes. So in other words, this could be running in the background, even if you just utilize a certain app. Depending if you're a criminal defendant, that's not good for you. But if you're the victim, this is good for you, right? Because they can figure out what happened. So, okay. Did that help you guys? Yeah, phone GPS is not a thing. GPS, and I don't really know enough about how GPS works, to be honest. I use satellites. Probably somebody in the chat will know, right? It is so detailed. Yep. This is a masterpiece. This timeline, 88 pages. It's every page on here is a masterpiece. Just literally minute by minute by minute. Actually, it's more specific than that. Down to the second, they're like, here's what everybody was doing when. But yeah, phones don't use GPS. I don't know why. Does anybody know why? So yeah, with phones, you've got the two things. You've got the cell tower, again, general area, unless you're in like a big city, but even that is still not as good as the second thing, which is iPhone location data. That essentially replaces GPS. But again, I just don't know how that works. Does anybody know, again, Android users, y'all, do you guys have iPhone location data? Or do you have some other thing, location data? It's funny because like you just always hear in trials, it seems like everybody has iPhones. So that's what you hear about. Right. And he never pinged at the actual house, right? Are you talking about the Prius Top Cat with Adelson's? Are you talking about the getaway Prius? I don't think you're talking about that because they have those fools pulling up to the ATM in that Prius to deposit their freaking money. They have those fools everywhere. It's like they did not criminal well in that those fools in the Prius, as I said. Okay, so Gwen, are you an Android user? I would love GPS am I talking about? I don't know what you mean. Okay, thank you, Gwen. So Gwen is an Android user. So do you have something else? Is there a different system on the phone to store location data that's just called something different? I mean, I would imagine there has to be. I just again, in all the trials I followed, I don't know that I've ever heard of that. I feel like it's just, yeah, they have those, again, the two fools in the Prius, again, Adelson case, they have those fools pulling into the toll where you pay the toll or whatever you call it, toll booth thing. They have them pulling up to multiple ATMs actually. So yeah. Okay, so there is a different system. Okay. So yeah. And of course, the biggest thing of all here was that Snapchat video. So yeah, this is just, and the other thing that's so cool too is look at this, right? How to do it right is look at this on the sides. Those colors, they have a color for each person's phone. I mean, I'm getting goosebumps looking at this, and I've studied this and done so much with this. It's like, you know, every time though. I mean, look at this. That is showing when the people, look at this, when the phone is locked, when the backlight is on, which means someone might have picked the phone up, and and then you have all the steps. It gets just when you thought it couldn't get any better, right? So like here in red is Alex. Alec Murdaugh's phone shows 283 steps, and it's going to bracket for the duration of that thing. And then like on the right-hand side, Paul Murdaugh's phone is locked. And like on the blue, Maggie's phone is locked. And the brackets, incredible, right? Absolutely incredible. Because this case was this is my favorite trial and case of all time. Anybody who doesn't know, anyway. But one thing that was really important about this trial in terms of the whole like just in the world of law, is that this is the first case where they proved time of death based on the cell phone usage, not just cell phone movement, but cell phone activity, and namely with Paul, because of how he was constantly on his phone. Actually, Josh Ritter, I think, or no, sorry, no, it was Bob Motta was actually talking about this. He was on, it was when he came on Lawyer, for any of you guys who saw that, and Bob Motta was on there. He actually mentioned it, and this was recently, and I was like, I love it whenever Murdaugh gets brought up, right? But he mentioned it. He said that what was so mind-blowing is they proved time of death based on the cell phone activity, like when it locked, when it unlocked, the battery level came in, being on low battery. So it went, of course, it was also things like apps and text messages and phone calls, but it went beyond that. Like this was so specific. Steps, the backlight, right? Incredible. Like literally, they painted you a picture of this person as if you were watching them at the time, holding their phone, and literally, were they moving their phone? Were they turning their phone over? What were like incredible, right? It's just okay. So, okay. So now we'll go back to what we were doing. Huge side tangent there, sidebar. So, okay. But again, this is what you hope for, right? For any of these other cases, this is the world that we live in, right? With cell phones, this is what you would hope to have in any case, is the ability to do like what they did in the Murdaugh case. You don't always need it. It depends on what else you have, right? But in some cases, you need it. And yeah, so yeah, they don't call it phone GPS. They call it like location data, I think is with a technical name, because it's not GPS. Now on Android, it might be called GPS because GPS uses satellites, right? And the iPhone location data is a whole different system. I don't honestly remember. But they don't call it GPS. So, it's like they've got their own system for that. But yeah, they use location data. Now they would use GPS for like a car, for like, in the telemetry, they would call it GPS because that uses satellites, I believe. But y'all can correct me if I'm wrong. Again, this is GPS, I feel like, is just less discussed, really. And well, I guess it's discussed, but sometimes people might say GPS, but it might be just referencing, do we know a location, right? You know what I mean? Sometimes it might be just used, but that doesn't actually mean it's GPS. So anyway, okay. So back to what we were listening to here.
Is this happening?
Yes.
So this is her talking again about them using these loopholes, these workarounds. And the last thing she had talked about was how if they law enforcement, they just upload as a consumer and then they can see everybody, right? Does this happen? Yes.
If I'm an attorney and I have a case where genetic genealogy is being utilized by law enforcement, and I want to know if they follow the protocols and rules, do I need genetic genealogy information that like you produce as a forensic genetic genealogist? Do I need that information?
Do I need that information? She's asking.
If you wanted to know what the process was, whether or not there was work product, if you wanted to verify how did you come to your conclusion, absolutely.
How about if I wanted to know if the rules were broken?
What if I wanted to know if the rules were broken? She said.
You would need the data.
Right.
You would need to see the data.
That's crucial. So remember, the whole point of this was for them to say, here's why we need to see the data, because we don't have any data, right? That last question, what if I wanted to see if the rules were broken? How do I see if I knew that any rules were broken? You would need the data. remember, there's a reason she's asking these questions.
There is. It is a very tedious process. There is a lot of time, effort, and work that goes into it. In the end, what I provide to law enforcement is an investigative lead, and it is up to the agency to then take over their case and confirm that my lead is in fact correct.
Okay. So this is the next thing that's wild, right? So here's the thing. So what did she just say? Basically, yes, they need this information so they can see if the lead was correct. I mean, like she just said, right? They need the information, they need the data. But then there's a problem, right? So remember, so the FBI, according to the state, went hard at work creating this family tree with hundreds of relatives, right? Remember that all the names at the beginning of this live stream when we were talking about the names, right? And I was like, don't worry, it's going to come up. All these names of the distant relatives of the hundreds of people, right? Okay. Well, remember, the private lab, likely Othram, started making a family tree, partial family tree, right? Was the language used. So in other words, the vast majority was done by the FBI. Well, wait, there's a problem. Because much of the information relied on by the FBI was only viewed through their user portal in the publicly available genealogy service databases, right? The FBI did not download or create copies of those records. So, and there's more. This is just one, essentially what is in every single document, right? Is the FBI doesn't have anything. They don't have anything. They only have like handwritten notes or some shit, right? They don't have anything to turn over. So that brings us to this question. If the FBI did the bulk, according to the state, right, of this huge ass family tree and all this with the IGG, which I still, I tried, y'all let me know. I tried to verify that the FBI even does this. My understanding was that they didn't. My understanding was like, they don't actually do this themselves. They outsource it. Now, when I tried to look into this, it looks like some FBI agencies in certain states are starting to learn how to do it. So I couldn't find a definitive answer. Like what I was looking for is, was there an answer out there that would say, yep, the FBI everywhere in any state has been and still does, right? Like they totally can do this. And the reason I was looking for that is because I always look to disprove. If I have a thought, right, or a theory or an idea, I always try to disprove it, right? So I was trying to disprove it because my impression had been, right, that the FBI doesn't do this. Again, in some states, it sounds, from what I could find online, some states they're starting to. But think about it, right? Because that's why they outsource it. That's why they hire somebody like Gabriel Vargas, or they go to Othram, because they haven't learned how to do it yet. And it's like they're in the process of starting to try to do that. But like this is all new, right? So that's one thing, right? So, but anyway, the FBI and their huge ass family tree with hundreds of names and all that, right? And they don't save anything, right? So then, okay, so whether or not it's true that any of that happened with the huge ass family tree, right? You still have the problem. The FBI didn't save anything. They have nothing to turn over. So then where did the IGG discovery come from? If the bulk of it was done by the FBI, allegedly, right? Supposedly, and they don't have anything, where did it come from? Well, it would have had to come from Othram, or the private, again, is likely Othram from what we know. It would have had to come from that. So, but what are we working with there? Well, we're working with, right, the partial quote unquote family tree. Another great question here. Are they trying to get the indictment dismissed on this IGG issue? Did they already, I'm trying to remember, Heather will know. Did they already, I feel like they already, so there have been already motions to, early on motions to dismiss, but that would have been like, okay. In other words, with any criminal case, motions to dismiss an indictment would happen early on. And that would have been, they would not have known the IGG issue at that time, right? They wouldn't, in other words, that the timing would have been off because it took time. It would have taken time for them. It did take time for them to start to see, and part of the reason it took time was because the state didn't want to turn over discovery, right? Not just the IGG discovery, but all the discovery. But even, they had to fight like hell, as we said, for them to get the IGG discovery of whatever it was. And so, in other words, it wasn't until October. Here we go. It wasn't until October of 2023, the judge at the time, he ruled that they needed to turn stuff over for the IGG. So the defense did not even have anything pertaining to the IGG until after October of 2023, right? So that's almost a year after the homicides. So hopefully that kind of makes sense. I don't know what the question mark is for, but hi, Adrian. Or Adrienne. But I see why you're asking the question, because it seems like, doesn't that seem like a normal thing? Like that's a reasonable question and a reasonable thought to have looking at this, right? And maybe now, are we seeing why the defense has been fighting to have this made public? So yes, so we were just saying, so where did the discovery come from, right? And whatever it is, again, is at best partial, right? That's according to the state, because again, remember, they started it and then they were asked to stop. But then the other question that I've been asking you guys, right? Why? We're going to take a look at the calendars here, because what we've got is immediately sent to Othram, right? They would have had their search results on or before November 29th, right? And then they are asked at that point to stop working on the case, because quote unquote the FBI is going to take over, whatever, right? But at that point, if they're asked to stop working, what that means is they turn over what they have. So go through this with me, right? DNA, SNP sent to Othram, right? Let's say, so Othram, they do what they do, and then they submit it right here, submit it to a database. Whatever search result they get, whatever that is, they have it on or before November 29th. The local law enforcement says, okay, you can stop working now. And so then, remember, like we heard Gabriel Vargas say, so then Othram would turn over their search result, because they are not working on it anymore. They turn over what they have, their search result, they turn it over, right? Okay, so here's we go. So again, this just puts it into perspective again, right? There's the homicides. There's the bolo for the white Elantra on November 25th. Look at this, right? So remember, they don't know who Bryan Kohberger is, in this week, the week of the 13th, right? It's like, remember the question, how did they get his name? How did he become a suspect, right? That's what everybody's been asking, right? Well, on the 29th, right? Othram invoice. So at this point, Othram has done their search, right, in the database, and it's maybe a partial, again, family tree is a stretch, but whatever result that they have, right, is turned over to local law enforcement, and they stop working on the case. So I guess actually they were asked to stop working by local law enforcement, but they turned over their search result to the FBI, just to clarify that. They were asked to stop working by local law enforcement, but they gave their search result to the FBI. So then on the 7th, there's the Elantra being announced as a vehicle of interest publicly, right? And then again, this is where shit gets crazy. Oh, what? It was supposed to update. Why didn't it include? Hold on, let me see what the next one is. So I had updated this to include that on the 15th. Yeah, weird. Why was that not updated there? So it was supposed to have, I thought I fixed that. So I had added, because we talked about this on the last live stream, a question came up of when was it that they pulled him over, right? Going on those body cam, going across the country. It was on the 15th. And I thought I had updated this to include that the 15th. It should be here. I'll fix it for next time. So on the 15th here is when he was seen. He was pulled over in Indiana twice, right? So then, but here's the other. So then on the 16th, he's observed by law enforcement at a CVS in Pennsylvania. Correct, Top Cat. Right. We don't know how far. Right. So on the 16th, he's being. I mean, it's in by law enforcement. Ostensibly, it's the FBI, right? The FBI, right? Remember. That's why I clarified it earlier, right? That the investigative lead, quote unquote, right, was turned over to the FBI. And so you've got Idaho is still like, look for a white Elantra. Meanwhile, he's in Pennsylvania across the country and the FBI's following him to a CVS. Okay. Now, this is the important thing. Again, that's why I'm glad I clarified it, because on the 19th, that is when the state, and specifically in the document, it says local law enforcement, right? So local law enforcement identified, then got, in other words, right? This would be when the local law enforcement got the name, right, through IGG, or identified him through IGG. But remember, the FBI was the one who got it initially, right? And again, we know there's no question that the FBI knows, because they're already there in Pennsylvania on the 16th. Like, not only have they identified him, they know where he is, and they've followed him to Pennsylvania to the C, but Idaho, right? Moss, they don't even have, like, you see what I'm saying? Like, this is insane. And then this is the last, and then there we go. There's the last week there. I'm really mad it didn't update this on the 15th, because I fixed it and I must have just clicked on the wrong things to upload it in this video, because I fixed it. Anyway, but yeah, again, just imagine, guys, with your imagination. On the 15th, it should say that's when he gets pulled over in Indiana. Okay. So what's after this? So then I've got a couple other slides on here. So do you guys see where does this lead us, right? Because we have to remember, why did that testimony matter from, well, a lot of her testimony, but especially the part about the loophole, right? Why were those questions asked about getting names for people that opted out, right? And I've said this before, I'll say it again, because it's especially relevant, right? When I did the thing, right, submitted my DNA to MyHeritage, right? And like, literally I had the thought, I was like, wow, I wonder what's going to happen when somebody commits a crime and they have and they didn't think they were going to commit a crime, say, right? And like, so let's say that they did one of these things, the DNA things, right? And they opted in, you know, and then maybe at some point in the future, they commit a crime, and like they, you know, there's DNA at the crime scene, right? Like my thought was like, what's going to happen when somebody matches to themselves? But again, in the thought, it was like filtered in by people who would have first opted in, right, for law enforcement to access it, and then later on committed a crime. But when you include in that everybody who's also opted out, what you get is everybody who's ever used any of those databases with their DNA, right? You get the opted in and you get the opted out, which means that's everyone who's ever submitted DNA. And so that question of it's just a matter of time, like what's going to happen when somebody gets a match to themselves, that speeds that process up. If you say, well, now even the people who opted out, I mean, I would imagine probably more people opt out. I would imagine that the majority opt out, probably, you know? So however many people have opted in, and then you say, well, now you can take that number and, you know, it increases by however many fold, but that means your odds increase, right? Of somebody committing a crime and then matching themselves, a direct match, right? Right. So the whole thing is this, right? IGG is technically this process, right? Where you build out a family tree and it takes time. It takes time. And that's how it all started. The way it all started was because the reason that it started is because there was a need to do that. Why was there a need to do that? Because at the very beginning of all this, right, whenever these sites first started, you know, these direct-to-consumer databases, there weren't that many people that had submitted DNA. So what happens is the more over time, right, as more people submit more DNA, you have more, it speeds up the process, right? But the whole point of it was because, you know, however many people are on the planet, right? And then if you submit your DNA, you're one person out of however many people are on the planet, right? It's like, the whole point is that it's going to take time to try to get these connections and to have more relatives identified. And it's going to take time also, as in time for more people to just choose to use one of these, you know? So again, so the idea, like IGG in its inception is all about using a family tree to identify people. But you know, again, so what am I trying to say? Without anybody having known, right, that maybe eventually, like the point of it, right, is not to get a direct match. That I'm articulating the point of it is not to get a direct match. The point of it is that you're going to get a family and all that. But just because that's the point of it doesn't mean that it couldn't or wouldn't eventually happen. And that, again, those odds increase as more people have, you know, you've got people committing crimes, right? And then as more people have submitted DNA. So in other words, that's why I kept saying IGG in scare quotes, right? Because essentially, like, for example, again, I've done this myself, right? So for me, if I went back, if I pretended I didn't already submit my DNA, right? Or if I pretended I was someone, if I went in there, right, and submitted it again, right, onto my heritage, whatever, like I would get a direct match to myself because I've already submitted my DNA, right, to it. So I would get a direct match to myself. So that wouldn't count as IGG. Why? Because IGG involves an investigation. It's investigative genetic genealogy. It's the whole thing is IGG is building out this family tree, right? So it's like, if I just use an IGG website, but I get a direct match to myself, it doesn't mean that I've partaken in IGG. Does that make sense? Because the IGG is the family tree part of it. So that's why I've been saying IGG in scare quotes. And that would be it would be true for anybody. If you have an S&P profile and then there's a direct match, you don't build a family tree, right? Here's one person, bam, right? There's your tip, quote unquote, right? There's your lead. I mean, and I say that again because it really is a lead. The way this normally would work, where you do build a family tree and you get, like in cold cases, right? They end up with like a second cousin 5 times removed or whatever, right? A distant relative, right? But that's the closest they could get to the actual person's DNA. That would be a lead. Why? Because you have to go talk to that person and see if you can figure out. In other words, you just don't have a name of a suspect. You just have a distant relative. That is a lead, right? But if you get a direct hit, I mean, again, normally they're turning over an investigative lead, but again, that's because that's normally what they have is a distant relative. In other words, nobody had planned for this, right, ahead of time to, and again, even if everything is so far behind to catch up to this, like this. So you guys see what I'm saying? Like this like the potentiality of people just direct matching to themselves is like a whole other thing that was not expected, I guess, if that makes sense, right? Again, it was the whole thing was about building these family trees. But if you just access the database, right, you submit it onto a database and you've already, again, prime example, I'm raising my hand. I would get a direct match to myself. There would be no distant, because they're going to give you the closest match. And if it's you, then that's the name, So am I making sense to you guys? So in other words, could Bryan Kohberger have been a direct match to himself, right? And if that's what happened, I wouldn't. If that's what happened, it would explain a lot of things. Here's what it would explain. It would explain. Why Othram was so quickly to get a result, right? Because by November 29th, how did everything happen so fast? This is the amount of time that elapsed, just by the way, is not enough time to actually do IGG, right? The whole thing about the family tree, that's why I kept saying, hundreds of relatives, like it takes months, if not years. So anyway, but never mind that. You got homicides on November 13th. Again, we don't know the date that the extraction was finished. We don't know the date the DNA was sent, right? But it was after November 13th. And by November 29th, we have a result from Othram, right? They took the S&P, they put it into the database, they got a result. That result was given to the FBI. And only 2 weeks later, the FBI is following Bryan Kohberger in Pennsylvania. So if he was a direct match to himself, it would explain how the hell any of this happened in the timeline, right? And it would explain why they were asked to stop and for the FBI to take over. Because you see what I'm saying? Like, that's why this question is up here. Like, if they got a name, if they got a direct match, well, they're done, right? And then the other factor there is if it's somebody, if that's what happened and he had opted out, right? Then the other question, why would the FBI take over, right? So if there was a direct match and he opted out, why would local law enforcement later on benefit from that? Well, because of what we already looked at. What happens when they ask the FBI for discovery with the IGG, right? We don't have it. We deleted everything. We don't have any records. We have nothing to turn over. So The last thing I would say is this. So why, I don't know that anybody's asked this question. The question then would also be, right? Why was it that the name, right? Look at the top of this picture. Why was it that the name, the defendant's name, was not provided to local law enforcement by the FBI until December 19th? Why? Like, why is that? So remember, the FBI has gotten this stuff a long time ago. They turn it over to local law enforcement on December 19th. And meanwhile, prior to December 19th, they're doing whatever the fuck they're doing in Moscow, which is just, you know, you all know. They're looking for a white Elantra and searching WSU data, you know, whatever. So, and remember, there's a lot of things that happen on November 29th, right? Because that same day is the day that you've got the WSU queries and all that. But anyway, I don't want to, we could talk more about that, but let's stay on topic. Well, not that it's not on topic, but anyway, let's stick with the first question. So why would they have waited, right? Oh, that's hilarious, Heather. So if, indeed, again, if you go with the thing, what if Bryan Kohberger was a direct match to himself? And what if he had opted out? Or what if the FBI, you know, utilized one of those, they did a search as like a consumer, right? They broke the rules, they did all that, like the stuff we already talked about. What if they did one of those things? Then potentially, would there then be a need to try to make it look like that didn't happen, as in more time needs to have elapsed, right? Like if you broke the rules and you got a result right off the bat with who it is, but like everyone will be like, well, how did that occur, right? Like how the hell did, like, obviously that's what the whole point is, right? It's like, how did that happen? But, and the only way you can answer that would be then also you would have to admit you broke the rules, you broke the law, whatever, you know, you did all those things. If you're the FBI, right? So maybe the answer there is you delete all your work, you delete all the stuff, you have nothing to show, you have nothing to show for what you did, and you wait to turn the name over to local law enforcement until after it looks like maybe they've done enough to where it looks like they could have found the suspect another way. And to also maybe try to make it seem like there could have possibly been any actual IGG going on, right? Because again, that takes time. And that's the other thing, right? Like had they, like if all of that is what's going on, and had they turned it over, again, ostensibly, remember, they got results from Othram was done on the November 29th. So let's just say that if you're the FBI and you get a name on November 29th, right? And you turn that over to local law enforcement or whatever, and then it's like, well, how did you get there? Oh, we got there because of IGG. You know, again, because if you broke the rules, you would have to say that, because you can't say it was a direct match otherwise, right? They can't admit that, right? So, but if that was the case, right? And then they're like, oh, we got it through IGG. They'd be like, yeah, you did IGG in like what, overnight? No, right? It'd be completely it's still implausible with the timeline, but you see what I mean? At least December 19th is better than November 29th. At least that's a little bit further away, right? And the thing is this, right? If in any case, criminal case, right? In any criminal case, if they get a direct match, but the person has opted in, right? And law enforcement, let's say that law enforcement doesn't break the rules. They don't use a loophole. They upload it properly as law enforcement. They don't do anything weird that way. And they just get lucky. They just get lucky, right? And it's like, oh, that person submitted their DNA and they were opted in. Then that's fine. They can, that's fine. That's legitimate, right? So the problem is where you run into the problems, right? Is where if you get a direct match like that and the person themselves is the defendant and the defendant had opted out, and the way that you obtained that was by breaking the rules. Does that make sense? Correct. That's exactly right. Right. You don't necessarily need a direct match. Correct. And you wouldn't even be expecting it again. But that's why, again, the question I kept thinking to myself is it's only a matter of time before it happens. Like, again, that's what would happen if I did it. So you don't need a direct match. And that's not the point. The point of IGG is you're not expecting a direct match. You're expecting a distant relative, and then you narrow it down. So that's exactly correct. But again, and it was in one of the documents we covered on the last live stream where they actually mentioned that, about how they called it a cold hit. I don't remember what that was in, but anyway, where it could happen. It's like, in other words, somebody else besides me had that thought, like, boy, I wonder what's going to happen if somebody matches to themselves, right? And gets a direct hit. Again, that would just be getting lucky and would not have been expected. And even the thing with like using any of the loopholes and like doing the backdoor stuff and getting the list of people who opted out. Again, if that's what happened here, well, we know it happens in cases. We already heard that. But if that's what happened here, it would be, again, hoping to get a closer family member or whatever. But again, it would have been a matter of just getting lucky if the defendant himself had done it, and that would be what you got. You got lucky, right? Right. And that's the other thing. Heather's putting into words what I tried to show in my calendar, right, on the 29th. Let me go back. Oh, wait, I'm not. Hold on. So remember, now, and the law enforcement that located the car that is referenced here in this comment is WSU. Right here. Oh, I need to pull this down. So on the 29th, right? Authorman voice. WSU Tiengo carried white Elantras, and then by happenstance, quote unquote, 30 minutes later after Daniel Tiengo queries the Elantras, right? They don't communicate. We covered all this in the last live stream with literally what's in the documents from the affidavit, that like just by happenstance, 30 minutes later, a separate WSU officer just happens to be driving around looking for white Elantras. By the way, it's in the middle of the night, and happens to drive by a white Elantra at student housing, and it's Bryan Kohberger's Elantra on the 29th. And that is why that's why I did all this, because basically this business here on the 29th, I think pretty much proves for a fact that they got a direct match. Again, the Authorman voice. So like homicides on the 13th, and you see what I mean, right? Like that they got a direct match. But the thing that's so funny is that, and here's how it works with the FBI, right, guys? When you ask the FBI to start working on a case, they remain doing that until the local law enforcement agency tells them, okay, we don't want you anymore. So what happened was initially MPD asked for help from the FBI, right? And so, if, and it looks like it did, right? The FBI gets whatever they get from whatever they're doing. They're going to keep doing their thing, aka showing up in Pennsylvania on December 16th, for example. They're going to keep doing they're going to keep working the case, right? Until they're told not to. And why does this happen? Because local law enforcement wants to be able to reap all the rewards. They want to be able to say they did it. And we see this in small towns a lot, right? Like they want, so the FBI does the work and then they want the credit. That's what it comes down to, which is really stupid, right? That they want to be able to say, yep, we found him. So meanwhile, again, what would that look like on a calendar? Well, it would look like what we have. Like it would look like, FBI's got him because and again, if what I'm saying is accurate, is correct, they got lucky if that's what happened with a direct match, right? But, like they are there in Pennsylvania on the 16th, right? And they're doing all they're doing all the things, and then I think that where the state probably took it back and wanted to say, okay, right? So here on the 19th, what would have happened here, I would imagine, is that when the FBI, so the FBI would have turned that over. That's probably when they said, okay, we don't want you anymore. I mean, I don't know. This is just what makes sense logically, right? We want it back. We want it to be our case, okay. Like, so then they turn over the name, right? And that would be what we have here on the 19th. And then we have, ironically, on the 20th, this business from Brett Payne. And guess what? How he learns it, right? Speaks with an unknown WSU officer because he doesn't name him. And first learns of white Elantras. And essentially, this would be like Moscow took back the case, if you will, right? MPD. And the FBI did participate in the arrest, but the thing is, though, is that has to do with Pennsylvania. So that would have been, and I was going to say that anyway, that the arrest, that would have been Pennsylvania law enforcement. I don't know that MPD would have had any say in that. Because like the arrest warrant and all that stuff, that's all out of Pennsylvania. Right. Again, on the 16th, I think that that's the FBI in my estimation. The 16th was FBI, right? Because FBI's already like cracked the case in their mind, right? Like they solved it if they got a direct hit, they solved, that would be it, right? That's when they've solved it, allegedly. Like there you go. Like if you're trying, the whole point is you've got DNA, you're trying to see whose DNA it is, and then you get a name, and then if you're the government, you're like, that's the person who did the crime, right? So yeah, top cat. So most are, but again, they just said in that recent filing that we went over earlier tonight that it looks like we don't know yet for sure about the 23rd and the 24th. But I do have a playlist on my channel too. I started covering this in May. But every hearing that's been public, I've covered, and you can see that on the playlist too. And I will continue to cover them. So we hope they will be public. But yeah, literally anything that's public in every court document, every hearing, ever since I started covering, I've done it, we do everything. We do it all. We read we read all the things, we go over all the things. And in fact, most people don't bother doing all the death penalty motions, but I've done every single death penalty motion in this case. And also I'm doing all of them with Shanna Gardner as well. And Pennsylvania State Police. Right. So again, that would have been because it was in their jurisdiction in terms of the arrest, you know what I mean? So that's why the FBI would have been involved there. Right. And this is another thing. I brought this up on the last live stream too, right? Because it was insane. But again, if it was supposed to be the FBI's case, like that's what I would imagine, right? Like like FBI had to have been in communication with Washington State like, right? And the other thing too is, right, it's even though there's only 10 minutes apart, it's a different state. So even though it's like common sense and like wouldn't you just call your friend up? Like, but in terms of like legally, right, you've got the different jurisdictions. So if you could have FBI taking over a case in Idaho. You could have FBI communicating with people in Washington State. You could have FBI working with Pennsylvania State Police, right? And then after, they got what they need and blah, blah, right? And then in Idaho, they can be like, we did it. Yeah. Yep. And this is where we started out talking, right? I'm just going back in the chat here. So this is what we started talking. Remember the names? See, I don't like to get ahead of myself. I wanted to wait. So that's why we talked about this stuff, but I'm like, wait, we'll see. You guys will see, right? The whole thing about the names, right? And I know Top Cat was asking about the names and I referenced it, right? I was like, yep. So remember what I said? I hinted at it earlier and I said, it could be because there are no names, right? Or it could be because it's just one name, right? Remember when Top Cat was asking like about, well, I was showing how in the document the defense says there's no names listed, right? Yeah, because there aren't any, right? So oh, that's another good point because the cameras would be overwritten. That's a good point. Yeah, I guess my thought is in terms of the waiting 30 days, I guess my thought was so that then they could try to pretend like there was enough time to have actually used IGG and all that, right? And also to make it look like there had been enough time for local law enforcement to have come to a suspect in a different way. If the whole, because the whole thing is this, right? If they got a direct match and it was a backdoor thing, he had opted out, then your next step, you've already solved, you're already in their mind cracked the case, quote unquote, in terms of you've got a name for the DNA. So your next job would be to make it look like that didn't happen and that anything else happened, like that you came to the suspect in any other way but that. But it's a problem but you already got the answer. It's like cheating on a test or something. Like you already know the answer and then you have to pretend like you don't know the answer. And then, but if you already know the answer, it would be hard to pretend you don't, type of thing. Like now you have to go through a different type of effort where it's like, you got to make it seem like you got it legitimately, right? So how do you do that? But all those things I think are the case. And I think also, again, the cameras would be overwritten is another good point. Yeah, I always forget who's Don Daniels again. I can't remember. If anyone can remind me who Don Daniels is. So, okay, so I'm still so mad that it didn't update the thing on the 15th, but whatever. Okay, so now, oh, what have we here? I've got more planned for you guys here. So, okay, so let me back this up a second. Okay, so now let me pull this up. Okay. It is, oh, well, actually, that's a good opportunity to, where is it? So, yeah, again, this is the thing with the names, right? No names. Yeah. And, also, right, no names of the extended family tree, right? You could say that, and that could be true if there's only one name and it's the name of the defendant. There wouldn't be a name of a family tree, right? Okay, so, but here's what I was going to do. So, okay, so this is from the the Journal of Law and the Biosciences. So, okay. We're not going to read the abstract. Okay, background. Here we go. So this is going to be all about the law, right? This is from the law journal, again, the Journal of Law and Biosciences, and then IG. And this is recent. This is from June 2021. And so there's some really good information here. Okay. IGG is a new technique for identifying criminal suspects that has sparked controversy. The process of IGG involves uploading a crime scene DNA profile to one or more genetic genealogy databases with the intention of partially matching it to a criminal offender's genetic relatives. This articulates what I was trying to say earlier about you don't expect to get a direct match, right? But it could happen. This says it beautifully, the intention of partially matching it to a criminal offender's genetic relatives. And eventually locating the offender within their family tree. In April 28, okay, we don't need to read that. It's Golden State Killer. Okay. Most of the major firms that maintain genetic genealogy databases, including Ancestry, 23andMe, and MyHeritage, have adopted policies that forbid law enforcement from participating in their databases for investigative purposes, either through requirements that users provide their own DNA for analysis or explicit bans on the conduct of IGG in their databases. However, in December 2018, Family Tree DNA, which maintains a genetic genealogy database consisting of 1.15 million autosomal DNA profiles, adopted a policy permitting law enforcement to participate in its database to identify violent criminals and human remains. FTDNA database participants can choose, this is the opting in or opting out, choose whether to make their information available for law enforcement searches in a process known as law enforcement matching. Specifically, registered participants located in the USA are automatically opted in to law enforcement matching, but can choose to opt out. And again, this I think has since changed. We heard Gabriel Vargas talk about that, where now the default is opted out, and you have to choose to opt in. By contrast, on May 18th, 2019, all registered participants of the genetic genealogy database known as GEDmatch were automatically opted out. At that time, the GEDmatch database consisted of approximately 750,000 profiles. But by April of 2020, it was 900,000. Remember, like I said, right? The more people, I wonder what it is now. It's just wild to think about, right? However, GEDmatch participants can choose to opt in to law enforcement matching at any time. Individuals joining GEDmatch after May 18th, 2019 are required to decide at the time of registration whether they will opt in or opt out for law enforcement matching. In December 2019, GEDmatch was acquired by Verogen, a forensic genomics company. And in January 2021, FTDNA's parent company announced its merger with MyDNA, an Australian personalized genomics company. As more law enforcement agencies use IGG in investigations, the privacy implications of the technique have come under scrutiny. Privacy concerns associated with IGG stem from the sources and types of genetic information maintained in genetic genealogy databases, which differ in important respects from the composition of law enforcement databases, such as CODIS, because those people have been convicted of crimes. By contrast, genetic genealogy databases are populated voluntarily, right? This is like what we were talking about earlier, guys, with like the Fourth Amendment and stuff, right? That this is right. So these are just, they can't just take your shit. They have to have probable cause enough to obtain a warrant. By contrast, genetic genealogy databases are populated voluntarily by individuals interested in exploring their ancestry and family lineage. The genetic data that they contribute are autosomal DNA profiles. Unlike the STR, which is what they use for law enforcement, right? The SNP SNP profiles carry more information about a person's medical history and appearance. Okay. For those reasons, IGG represents an expansion over standard CODIS searching in terms of the population of persons whose genetic information might be searched in an investigation. Even if the search objectives are different, and the kinds of information that are the basis for identification. Although that is presumably known and accepted by genetic genealogy database participants who opt into law enforcement matching, the same cannot be said of all their non-participant relatives, whose names might become part of an investigation by virtue of the fact that they are members on a suspect's family tree. So all of this is speaking to, again, what is typically the case when you got IGG and, again, the family tree, like what we have talked about already many times today, and like the state's motion for protective order, where it talks about the hundreds of innocent relatives, like literally that's what it says, hundreds of innocent relatives on distant relatives, innocent, it uses both words, right? Innocent and distant relatives on the family tree, right? Like, again, that's Prosecutor Santa, in my opinion, using all the languaging to try to make it look like any of this was done normally, right? Okay, because most genetic genealogy database participants are persons of European ancestry, the privacy of their relatives is especially at risk. Moreover, IGG has reportedly been conducted in at least one database without the company's or their participants' knowledge and consent. That practice would violate the database's current terms of service, which explicitly prohibit IGG. While these issues deserve careful attention, we are concerned that their discussion is at times based on misunderstandings related to how IGG is conducted and used in criminal investigations and how IGG departs from traditional investigative techniques. Here, we aim to clarify and sharpen the public debate by addressing 4 misconceptions about IGG. We begin with a detailed description of IGG as it is currently practiced, what it is, and just as important, what it is not. We then examine misunderstood or not widely known aspects of IGG that are potentially confusing efforts to have constructive discussions about its risks and benefits. Along the way, we identify persistent concerns and controversies related to each misconception that might benefit from policy intervention. We conclude with broad recommendations intended to support the productivity of discussions about the future of IGG. So there's a question here. Do we know that right? That's a good question. So, the answer here, where it's like, he told a friend. I mean, we covered on a couple live streams ago, there are different articles where it talks about, like, there was like a neighbor. I don't know if it's the same guy. There could be more than one person who thinks he did, right? For me, this is just me personally. For me personally, some person saying, yeah, Bryan Kohberger told me he uploaded his DNA to a thing. Like, and of course, this would have happened after now this case, right? So, like, in other words, you have a murder, you have a quadruple homicide, you have Bryan Kohberger arrested, right? He's, all that. And then after the fact, you have people coming out and saying, oh yeah, he told me he did that. For me personally, that is not enough for me personally to say 100% that's proof. It would be the type of thing that I would wait for trial. I would wait for trial if it's going to come from witness testimony, right? Or, of course, there's other ways to prove things, like the discovery in this case could include something like, the actual, him actually registering and, like, you know what I mean? Like the receipt of paying for the services or what, there's other types of evidence, right? That could come in at a trial that could prove for sure that he did that, right? But for me, so I'm glad you asked the question, because, like, for me, more so than somebody saying they heard it, he told them that, right? Because anyone can make that stuff up, right? For me, the thing that is the biggest indicator that could have happened is just looking at what we just looked at, the timeline and the way this whole thing went with the time. Yeah. That for me is, I feel like I can rely more on that and just looking at logically the timeline and the order of events and where things happened when and all that. And we just went through that. For me, I feel more good about relying on that to say that could indicate, that he had done that versus, but that's just me personally. And in general, like, again, if it's like somebody gave an interview and said something happened, I don't use that stuff. Doesn't, I don't rely on that. As you guys know, I don't rely on that for any of the cases that I cover, any of them. If it's something directly from a defendant, right, where, and just to be clear again, now, if it's somebody's at trial called as a witness, right, saying the defendant told me this, then I judge that as we should, witness by witness, right? There's some witnesses that are believable and there's some that aren't. But in terms of, we're talking about people saying something after a case starts and they come out and they say stuff and it's, just to, the news or whoever, right? On social media, it's not, for me, that's not been vetted anyway, but that's just me personally. So I don't involve that in terms of, I don't rely on that for any of the cases that I cover for information. But right. So yeah. And then Heather again saying, I think the court filings definitely support that it was a direct match. Yeah. And the court filings, of course, well, that's how I built those calendars. So same, right? The calendars that we just looked at and the court filings that we've been going over, including tonight, right? Again, that's what I rely on to feel like that point indicates that could have happened. If he didn't, wouldn't that change everything? That's a great question. So if he didn't, let's pull this back up. Great question. Top Cat, thank you for your great questions. And everyone else who's been asking questions. Again, I don't see everything in the chat. Oftentimes I see things when I'm doing timestamps and I'm like, nah, I missed that. But okay, I'm only one person with one set of eyeballs. So let's walk through this, right? Like, how else? Let's walk through it. Like, if he didn't, the only way then what would have had to have happened is the FBI would have had to actually engage in some type of actual IGG, right? Where they get not his name. And that two things have to happen there. That means, first of all, the FBI has to do IGG, which again, like I said, earlier in the stream, is still not clear because it doesn't, like, I can't say for sure that they, okay, well, how can I say this? Because again, it's like the FBI in some states has been just recently starting to learn how to try to do this themselves. I would say that the fact that Othram was used, right, for me would be like, okay, probably that's because, the FBI agents in Idaho don't do it, right? So the first thing you have to ask yourself is, did the FBI in 2022 in Idaho, were they actually doing IGG? If somebody wants to try to find, like, I've done, I can't find that exact answer, but of course, again, like, everybody's welcome to try to find that out, because that would be very helpful to learn. And I don't know the answers on the internet. I really don't. But like, did those agents actually do themselves IGG, right? With just themselves? Because I don't think they did. But in order to answer that question from Top Cat, like what would it mean if he hadn't had submitted it? The first thing it would have to be is, it would mean that the FBI would have to actually be able to conduct their own IGG without the help of a third party, and that they were doing that at the time, first of all. And then second of all, it would mean that they had to have conducted actual IGG and actually built out a family tree. And they would have had to have done that in like a week because, again, we don't have the dates as to when the DNA was sent to Othram. But again, if we look at the 29th, right, that's when the FBI is going to take over. So they would have had this is the most time they would have had. They would have had max. Well, okay, so December 16th, they're in Pennsylvania at his house or at the CVS, right? So we know they would have had to have finished before December 16th. But again, the widest window, November 29th, because that's when the FBI takes over. That's when the FBI would get whatever Othram had, right? And again, if we're going with, again, the potentiality, it wasn't a direct match, then Othram would have had some distant family member, right? Or a partial family tree, right? November 29th would be when the FBI would get a partial family tree. They would have had to have gone from that to identifying Bryan Kohberger before December 16th. And I would say probably quite a bit before, but max window. So 2 weeks is generous. But again, the first question first is if they even do again, my thought is that I don't believe that they even do that work. They would have to, they're right. Hopefully that makes sense. And then, but also his rights wouldn't have been right. Correct. That's also true. Right. Yeah. So again, if he hadn't submitted his DNA as a sample, yeah, it would have changed it in terms of what I just mentioned. But yes, also his rights wouldn't have been violated. Well, not as it pertains to this. Now, there's other issues in terms of the search warrants and the affidavit. We've talked about. There's other issues that are, the motions to suppress that we've covered raise a lot of different issues. In addition, so other ways his rights could have been violated, right? But this is the biggest problem if this is what happened, right? Yeah, and as far as the timeline, I mean, in terms of part of the reason those calendars are so sparse, right, is because in terms of the major events for that pertain to these questions that we've been talking about anyway, it's shocking. There's just so many. When you read through the affidavit or you read through any of these court filings, there's more often than not, there's no dates. It's rare to get a date. The affidavit is lists all these different events, one after another, no dates. It was in, for example, hold on. Let me pull up, for example. Where is it? Okay. Okay. So, oh wait, I need to move this over here. Okay. So if you look at, this is from the one from whenever it was the other day. If you look at, let's see. I'm just trying to go forward because it's in here. It's in this video. I have a bunch of examples for you guys. So I think it's in this one. Or no, maybe it's in the, hold on. Wait, this is not the right one. Hold on. It's in, let me see here. It's in, Where the heck? It's in this one, actually. Okay.
Video.
It's in this one. This is what I was looking for. Sorry, guys. It's in this one. It's in this one. Okay. So let me just look for it. Aha, there we go. That's what I was looking for. Okay. So here we go. Like this is the rarity. You get, these are 2 dates in the affidavit. It's a rarity. We have November 25th and November 29th. And then here. So this is why I highlighted this stuff, right? There is a date, November 29th. Then you have all these other events, right? That matter. Officer Whitman ran the car ball, but then this part. So this is from the affiant, Brett Payne, right? I reviewed Kohberger's Washington State driver's light ball, all this, no date, right? And then this is the calendars. There's the 7th.
Time towards number 1.
Goodness gracious, we've already watched. Hold on, let me go forward to the next part. So okay, let me see.
Your affidavit.
No, that's not it. Where is it? Anyway, I've got more examples where it shows all these events. I'm just trying to find it where it has all these events that are important. And then it's like no date, no date, no date, no date. Might be in here. Let me just see. What's that? Anyway, well, yeah, I'm sure it's timestamped from the last live stream, whenever those were. But yes, so there's just not a lot of dates. That's my point. So yeah. So so the timeline is tough for that reason, really. You know what I mean? Right. Of course, it is strange in itself to not list dates. It's very odd. Yes, yes, yes. Yeah. So, but the other thing I was mentioning too is like, in other words, again, if he didn't submit anything to a database, right? Again, like his rights wouldn't have been violated as it pertains to the IGG, but there's other issues that are in the motions to suppress that are potential constitutional, rights violations that are separate and apart, right? In addition to, rather. And I don't know what sticker gate is. So again, Heather knows all the other external things related to this. Okay, so right. That brings us back to what I know what we were doing. We were doing this. Okay, so okay. So IGG step-by-step. Put simply, the IGG describes the process of using information about genetic similarities and known family relationships to generate investigative leads. The basic information used in IGG falls into 2 categories: genetic relative information, which is generated by a database, right, with SNP profiles. And it, also contains things such as like census records, obituaries, and it describes family relationships. Law enforcement integrates these 2 categories of information to develop family trees and then identifies and investigates high likelihood suspects within those trees. Thus, IGG comprises 2 steps that are bookended by standard police work. According to best practices, when an offender leaves a biological sample at a crime scene, an accredited forensic laboratory first generates an STR profile. If there are no suspects, the STR profile is then uploaded to CODIS to identify. And remember, we're going to see a diagram here. This is the next thing, uploading to CODIS, right? If the forensic STR matches a CODIS profile, then following manual confirmation of the match to ensure no administrative errors occurred, then you've got the name of the offender matching CODIS, and then that is considered an investigative lead. Why? That's still not enough. You still have to do other things. Keep that in mind too. Oh, what have we here? What have we here? I was like, oh boy, there it is. You guys ready? So basic steps. So there it is. Basic steps of a criminal investigation that involves IGG. So I was like, oh my God, this is amazing. Because why? We have the state's IGG tree, as I've been calling it, right? So this is here. So now Okay, so we've got here, this is the states, right? We've looked at a whole bunch. So this is what we just saw, right? This is from that, that law journal of what they're saying is the steps that should happen. So I broke this down for you guys. All right, so we have it color-coded. All right, so red color highlighted is the steps. If you've got an unknown, and over here I'm on the right, at the top right, unknown suspect's DNA plus CODIS equals check, as in there's your name, your investigative lead, right? Blue equals you have a known suspect, as in you know, it could be you already have a suspect, right? You have a known suspect, someone you think, but you know, you obviously you haven't arrested him yet. Known suspect, right? And then plus a direct match via a buccal swab. So that would mean if that means you've then had probable cause, right, for to obtain that buccal swab. So that you know, that happens in cases, right? They, you know, especially if it's like a family member or whatever, right? So known suspect plus DNA match via buccal swab equals check. Now yellow is pertaining to IGG. So when do they do the IGG? No suspect plus no CODIS match equals IGG. So now, up at the top, step one. This is also important. Step one is investigation. Step one is investigation. All right? And here it is. So again, in red, this is unknown suspect. So if no suspects, right? You have, all you've got is the DNA from the crime scene, right? But you put it in a CODIS, you get a match. The next thing is further investigation. Okay, now in blue, you've got a suspect, right? You then are able to participate in STR analysis, which means you've done a buccal swab, right? Now notice it says 1-to-1 matching. What that means, right? So you've got 1-to-1, as in here's their DNA. We know it's their DNA because it's from this buccal swab. We're gonna match it to the crime scene, right? That, again, if you have a suspect, and that's a match. Keep all these are assuming you get matches, right? But for everything, the next step after the match is further investigation. Okay, now step two. Now keep in mind, what's step one? Step one is put it into fucking CODIS, and we're gonna come back to that. Step one is put it into CODIS, right? Okay. Step two. If all suspects are ruled out and no leads, so then you do the SNP, right? Because STR is different, as we've talked about. STR is law enforcement, right? SNP is IGG. Again, in other words, that's what is utilized by the databases, right? You know, any of them. So SNP. And again, remember, SNP gives you a lot more information like we already were reading about. So then the genealogy, it would be step 3. And then step 4 down here at the bottom, investigation. Now you'll notice whenever the IGG is involved with the yellow, there's more steps and there's more investigation than the others, right? So after the genealogy is more investigation. And then after more investigation, that would lead you to, now here's the other thing. In these boxes, what have I done? So these boxes right here, if you guys can see my mouse, in the middle, that box is indicating they've got a lead, like they've got the name, they've got a suspect, right? They've got the name, they've got the person. And why, and what do I mean by that? So look at these boxes, what do those all have in common? CODIS matching at the top, then in blue here, 1-to-1 matching, AKA a direct match. And then at the bottom in yellow in the box, also 1-to-1 matching, direct match. So in other words, these are your confirmed, the person match. Now, this person matches the DNA at the crime scene. That's what's in these boxes, but these are the different ways you can get there, right? So again, we're on the bottom, step 4, investigation. So then you get to your box. What does this mean? It means that your investigation has led you to the singular name of the person who you know, if you're law enforcement, you think is the person that did it, right? And again, in the box, that means they have obtained their DNA through a buccal swab, right? 1-to-1 matching, and they've matched it to the crime scene. And then if that's a match, then what's the next step? Further investigation. Oh, happy to see you, Twizzlestick. I've heard a lot about you. You're a legend here because Heather talks very highly of you. So welcome. Glad you're here. That's really funny. But yeah, it sounds like you're also a local from what I know as well. So so that's awesome. Yeah, Heather and Twizzlestick apparently are best friends is what I so yeah. Heather's doing her wrong. Shout out to Glenn, by the way. Oh, legend here. So okay. So again, I just think it's so interesting how all of these, right? This is, you've got a person matches DNA at crime scene. And for every way that you get there, the next step is further investigation. Already that's interesting to me. Okay, so now, but that leads us to here on the right-hand side towards the bottom right-hand side, right? So again, just to reiterate, unknown suspect plus DNA, or sorry, unknown suspect's DNA plus CODIS, check. Known suspect plus direct match via buccal swab, check. And then again, on our last square here, IGG lead plus direct match via buccal swab equals check. And in case any of you guys was wondering, well, hey, can we put this side by side with the states diagram? Don't worry, I've got you. So, and the reason we looked at the big ones first is because now they're smaller, right? And also the other one we just saw had the color coding key, if you will, because I couldn't have room for it. So here you go, but you can still kind of see, right? So here's the side by side. Now, what's different is the order is reversed, right? So in other words, the first step in the states version on the left-hand side is at the bottom, which is already interesting, right? Why is the first, anyway, it makes more sense the way it is on the right anyway, okay. But the whole thing is, so let's compare, right? Because this on the right-hand side, this is how it's supposed to be done. This is how it's supposed to be done. And this is step by step. Okay. What did the state do? So look at the bottom here, right? I'm on the left-hand side at the bottom. K-bar from the knife sheath, right? Again, blows my mind because according to the state's order of events here, right? Remember what we said here? First step, you put it in CODIS. First step. It's the first step. But according to the state, they did that after they sent it to Othram. And you know, could this be in the wrong place? Yes, but also, couldn't they have put it couldn't they have put it in the right place? Yeah, they could have. Like, I don't know why they would put it in the wrong place. It's, you know what I mean? It's like they could have just moved this entire, you know, the arrows on the right-hand side. If they just moved it down a little bit, it would align up. Because I mean, ostensibly it should be lower than the Othram line, right? If that makes sense. It should be first, step by step, right? Like, we got an order of events on the left, we have an order of events on the right. First thing is CODIS. But if you look at this, CODIS was after. So I don't know. And so they got that part wrong, according to them. According to them, they got that part wrong, right? And also, according to them, two things that happened at the same time: SNP profile submitted to databases, which means they've already been, you know, Othram's already, like, ostensibly, again, this could have been somewhere around the 29th. But according to them, that happened, if you look at it, right, at the same time that they searched CODIS. I mean, which is interesting. So, and part of what's missing, right? So, like, where's all the investigation, right? Like we said on here, right? Like, looking at the steps in yellow. So if you look at step 2, and then you have the generation, the S&P generation. Okay. So where is that on the states? So that would be the profile created by Othram, generation. Okay. And then the genealogy, right, would be I guess that would be here where it says S&P profile submitted to genealogical databases. And then I guess where it says investigation, that would be genealogical research. And then again, if they're going by what was happening here on the what should have happened, right, according to the chart on the right, then that would have generated after the family tree with hundreds of people, right, was somehow magically done in like, record speed, then they would get a name, right? And then, of course, the one-to-one matching would occur after his arrest when they do the buccal swab. And then further investigation, right? Are you having troubles with Nightbot, Twizzlestick? I love Nightbot. Nightbot is the best. He has tiny hands, but a big heart. We love you, Nightbot. See, there he is. Oh, Glenn. Glenn was our troll that we had. He's a legend. Heather was there. Glenn was our troll. We were doing Adelson. We were doing Wendy's interrogation, and Glenn was a troll that lasted for 3 hours and 40 minutes before I had to kick him out. And it's like the only person I've ever kicked out. The only person I've ever kicked out. But like he started to go crazy with like political stuff. And anyway, he's such a legend that I have made a compilation video called The Best of Glenn. And we watched it, I don't know, like a week or two ago. And also we have this. We have a special swoop for Glenn whenever we're doing Adelson coverage.
I have that skirt.
Wendy, right, saying I have that, but that's Glenn. He's writing a book about Wendy. And Heather making a great point too. We shouldn't have to form a complex tree to make it make sense. I know, right? Yeah, and thank you, Topcat. I wonder how Glenn's book is going. Right on time there. Yeah. Glenn, if you are watching this, yeah. So that was like Glenn's favorite word was wrong in all caps. Like he would be in the chat just like wrong in all caps without anything else, just over and over again, among other things. It was great. So yeah. Did I put Discord? So yes. Also, let me put the link for the Discord in the chat. So for anyone else who's new, right. So, in other words, I think the biggest issue in terms of the order of events, right? Even if you assume that, even if you pretend like the state engaged, if you say, okay, fine, they, even if they engaged in any type of family tree or whatever, right? I mean, but even if all that is the case, which doesn't look like it's possible for that to be the case, but even if it is, in a hypothetical situation in another galaxy far, far away, still, they got it wrong with the CODIS according to the order of events. So, all right. So now we'll go back to our article. Here we go. I have like 50,000 tabs open. So this is the original here, right? So that's where I got this from. Okay. If the CODIS search does not result in a confirmed match, investigators usually attempt to identify and pursue leads through normal channels. Among other things, all right, this is what we call investigation, right? They conduct interviews, they collect and analyze evidence, and surveil suspects and their associates. This work might also include the collection of biological samples from one or more high likelihood suspects. The generation of, so like, for example, the family members, right? Or whatever, when they're like, hey, can we get your buccal swab? The generation of STR profiles from such samples and direct comparison of those profiles with the forensic STR profile. Again, just think of that as like DNA crime scene. crime scene DNA, sorry. But if these normal investigative channels, again, that's why it's so odd that the first thing was sent it to Othram, right? Like, you guys see why this is really hammering the point home. Like, when it's normally done when you've exhausted all other resources and you're shit out of luck, as they say, right? You've got nothing, you're stuck. That's why it's so odd. It's so odd. Okay, but if these normal investigative channels are also unsuccessful, an agency with the resources to do so might turn to IGG to develop additional leads. If it does, first, an S&P SNP profile is generated, typically by a private lab on behalf of the agency. This is because no U.S. forensic lab currently has the technology to generate SNP profiles. And that, I don't know if that is still the case, because again, this is from 2021. That might not be the case now. But okay, a consequence of the fact that, okay, just talking about resource acquisition. Okay, the forensic S&P profile is then uploaded to one or more direct genetic genealogy databases, each of which generates a list of genetic relatives and the basis for their identification, specifically the shared amount of and length of shared DNA blocks. So like, yeah, at this point, investigators or genealogists working on behalf of the agency search for genealogical and other information about the genetic relatives identified by the databases to develop a family tree that includes the source of the forensic sample. So again, that's step 3. In some cases, DNA samples might be collected from family members for S&P testing in comparison to narrow the search to specific branches of the larger family tree, like the hundreds of innocent relatives, according to Prosecutor Santa. So yeah, by the way, there he is, getting spicy. Okay, investigators then identify individuals within the tree who are high likelihood suspects because, among other things, they align with the known demographics or activities of the offender, and those suspects are investigated using standard techniques. This investigation might unearth new information about family relationships and result in expanding or modifying the family tree. Again, according to investigative best practices, the investigation eventually proceeds to the collection. Eventually, right? These words, because again, normally this takes time. Proceeds to the collection of a biological sample from a high likelihood suspect, the generation of an STR profile from that sample, and direct comparison with the crime scene DNA, right? If the profiles match, the suspect is subjected to further investigation and may be arrested if the totality of the evidence supports the arrest. If the profiles do not match, the person is then cleared as a suspect and the investigation continues on. They sally forth. Okay, 4 aspects of IGG that are misunderstood or not well unknown. Well, so there is what is it? I had a document. Well, it's on the court docket. It does look like they used the lab and I don't know how to pronounce it. Cordialine. I don't know how to pronounce it. Like I said, there's a forensic lab there, but I don't know what they utilized it for. But there is, because that's in one of the we went over it a few live streams ago. I forget what it's in. It's like a search warrant or something that mentions them. But yes, are you guys thinking we're going to see the IGG on the 20th? I mean, at this point, though, you guys, I don't know. Like, remember, y'all, like, I mean, for like, we need to not assume, because we'll be really disappointed, right? Like, right, look at this. Consider what portions, if any, and under what circumstances should the various motions set to be heard on January 23rd and 24th be open to the public, either live and or by video. Like, in other words, considering that people can't even attend, like completely closed, sealed hearing. Like, we can't, I prior to this coming out, I was under the assumption it's going to be, we'll see the hearings, but maybe not see the IGG stuff. And then after the IGG motions from the defense, I was like, oh, cool. Well, maybe we'll get to see them argue that as well. But then, you know, Judge Hippler was like, no, don't get excited about anything, because I'm going to crush all your excitement right now with this. And I'll tell you when I knew it was going to become bad is when I was reading along, and then I saw, consider what portions, if any. And I was like, that what if any? Already, that's a bad sign right? For, you know, it's now like an ominous threat. The what if any, thanks to well, initially it was thanks to Elaine, actually. There's Elaine's hybrid spirit animal. And then of course Lolly took that and obliterated the record. But anyway, that's the Lolly bird because he squawks. So well, now he just sits like a bump on a log and doesn't say anything, but he used to squawk. But I saw this and I was like, no, don't say it. And then he said it and I was like, fuck. So yes. But fingers crossed, guys. Those of you guys who are religious, pray. Oh, thank you, Coeur d'Alene. Right. And again, I think you are local, so I'm sorry for if I offended you by my not knowing how to pronounce that. But okay, well, that's good. I mean, well, if that's the case, yeah, I don't know. Then what was he thinking with that? I mean, that was from Judge Hippler. It was just wild. And again, Top Cat is in Australia, saying they don't televise trials here at all. Wow. So, okay, well, so I guess I'm not the only one that says that wrong. I know Mowery. Yeah. Well, and that's the other thing, right? Because guys, you know, in case y'all didn't see, there was also, speaking of it, Mowery. I mean, right here though, like whatever the exhibits are, right? Like, I don't know that we're going to see that at this juncture because it said there was no objection from the defense and now they've ordered it. His amended expert disclosure with his attached exhibits are all sealed. So, as pertains to Mowery. But yeah, wasn't it the DoorDash return? Who's CDA again? I can't remember what that is standing for. I mean, I guess it could stand for different things. DoorDash search warrant return. I think we looked at that recently too. I think also it was the same live stream where we also looked at the core. What was it? How did I say it again? I already forgot. Coeur d'Alene. We also looked at those were on the same live stream, which I don't know when that was, like 2 weeks ago, maybe, just estimating. So sealed till when? Good question. It says, I was going to read it and then I didn't read it. I was only the last sentence and I didn't read it, but it would have answered your question here before you asked it probably. Exempt from disclosure and sealed. Oh, it doesn't say when. I thought it was going to say until, but it doesn't. So essentially the answer would be unless and until there would have to be a motion to unseal. That's what it is. Literally, this will be sealed unless and until we get a motion like this, but swap out IGG suppression briefing with Mowery's shit. It would have to be a motion to unseal. So it would look like this, a motion to unseal. And it would have to, lay out what they want to unseal and why. So that's what would happen. Sucks. Oh, right. Duh. Obviously. Thank you. My brain didn't add those up. Yes. Thank you. Oh, good question. Yeah. So I loved Judge. Judge was the first judge until they had the change of venue. I know I loved Judge. The new judge, as of just hasn't been a few months, Judge Hippler is his name. I was calling him Judge Stickler. Then I was calling him around Christmas time. I was calling him Judge Grinchler. Really just based on the fact that on the day that he took over the case and they all met each other, I guess Miss Elisa Mathoff had practiced with him before, but apart from that, everyone else was there, showing up. It's like first day of school meeting the teacher, right? They show up for that first hearing, and he flat out is like, says, y'all remember that saw it, like, I don't want to be here. I'm not going to lie to you. I don't want to be here. I don't want to be doing this. And I was like, oh my God. It was like worse than that. I can't even do an impression of it. It was so grouchy and grumpy and like negative and just crazy, just weird. So that was why I nicknamed him in my mind, and I guess also call him sometimes Judge Stickler, and then it turned to Grinchler. However, so far I have had moments of being pleasantly surprised, in terms of his rulings. Like, for example, when he could have, like, for example, I guess the biggest one that I can think of is with the Franks motion, right? When he, said to the defense, like, hey, like, I want to be able to actually take this seriously. So, like, can you just make these couple of changes, be more specific with your exhibits and whatever? And he didn't just he could have just flat out just denied the motion, for that reason, but he didn't, So in other words, his words on the first day were like, grouchy, but his rulings, though, I think have been, we haven't seen that much from him yet because he's so new, but his rulings have been, I guess, how many rulings has he even had? He hasn't had that many. And a lot of it's just been stuff. Well, I guess he denied all the death penalty motions. But anyway, yeah. They've only had 2-3 hearings with him that have been open since he took over, probably 3. So, So, yeah, Twizzlestick says JJ was I'm glad you think so. Yeah, I really, he was in a difficult position. Here's what I really liked about him. What I really liked about him was his demeanor. I liked that he indulged Jay Logsdon on going through like these philosophical explorations, if you will, like, because that jives with me, right? Like the fact of like when, for example, when Jay Logsdon had those awesome motions with like, going back to like, the Magna Carta and all that, and like with the grand jury and stuff like that, right? And it's like, even though, it was going to be clearly denied, like Judge was like, still like, let's explore this issue. Let's talk about it. I really want to understand what you're saying. And it was like, just from a philosophical standpoint, right? And like, also he had a sense of childlike wonder about him, if you guys know what I mean. Like his smile, he has this sense of, I don't know what else to call it, like a sense of childlike wonder or vibe like that, and so I just personally enjoyed him. And, I know that some people think he was too slow or whatever, which, I would rather somebody be slow than like a Judge Gull or a Judge Bev, right? Like, and, you guys know, I'm not even going to get into it. Like, anyway, I think he was, and I think, so again, I think he was fair, like, and I just liked his demeanor. I liked his demeanor. And I also really liked his signature. Oh, so all the death penalty motions were denied. So it's still on the table. At this juncture. I thought the motion to trifurcate, I really thought that was my vote for like strongest chance of being successful. And I really thought it was a great idea. I wish everybody trifurcated it, honestly. Yeah, happy-go-lucky. Yeah, definitely. Mm-hmm. I know, an old hippie, definitely. And you know what? That's a good way to put it. And that would make sense, right? Because I like old hippies. I like hippies, in general, and just that makes sense. Yeah. Oh yeah, Exhibit PP. I remember that. That was funny. Oh, that's fun. So Judge waved at Twizzlestick once. That's nice. You know, I hope you'll join us too, because like that way when Twizzlestick, I'm speaking to you specifically, like for whenever we do other, you know, cover hearings and stuff, because that way you can like be in the chat and be like, there I am, and like point us out if you're like in the gallery, you know, like there I am. That's exactly right. He was just go with the flow, always pleasant. Yeah, right. Yes, absolutely. Yeah, exactly. That's what I liked about him. I just really liked his demeanor. He's honestly one of my favorite judges. You know, if I had to pick like a top 5, he would be in it. You got turned in for what? But yeah, so Judge, and you can see Judge Hippler's on the thumbnail as well too for all these live streams. Once he became the judge, he got put on the thumbnail. But he's very okay. So let me do a better job of answering this question for Top Cat. He's no nonsense. He's very much, even if you know, grouchy or not, or whatever, you know, like in terms of just like judgery, like he's very no nonsense. He's go by the rules, you know. If it's going to be longer than it's supposed to be, you got to file a motion and ask to exceed the page length. If you want another day, you got to make, you know, very, which isn't a bad thing, right? That's a good thing. That's a good thing in a lot, you know, and very serious and wants to just, you know, like for some reason the word militant came to mind, but that's probably not the right word. Strict is a good word. Strict. Yes, I would say he's strict. That's what I think so far would be a good way to say. Yes, because strict, you can be strict and grumpy or grouchy, and you can be strict and also not grumpy. So, again, because jury's still out. Maybe he was just grumpy on the first day. I don't know, but he's been strict through and through, I would say. So, oh, they tried to get psych. Oh, interesting. Yeah, buy the book. Yes, buy the book. Yep. Okay, so this description of IGG provides a foundation from which to dispel certain misconceptions about IGG that we have observed in the media and online forums and heard in private conversations. Are y'all listening in on people's private? That's just funny. Like what? The problem with allowing them to persist. So they're saying these misconceptions are dangerous, right? The problem with allowing them to persist is they potentially can confuse the public debate around IGG and lead to the adoption of policies intended to address concerns that do not reflect the current practice of IGG while misdirecting attention away from concerns that do. Okay, misconception number 1. When law enforcement conducts IGG in a genetic genealogy database, they are given special access to participants' SNP profiles. Some criticisms of IGG rest on the assumption that police conducting IGG have access to 600,000 plus SNPs. It is sometimes suggested that IGG gives law enforcement special access. Both statements are inaccurate. When investigators conduct IGG, they participate in genetic genealogy databases on at least the same, and in some respects, more restrictive conditions, which we heard Gabriel Vargas talk about, as other participants. But again, as we also heard her talk about, they sometimes break the rules and then don't do that because they pretend they're not law enforcement. When investigators participate in any genetic genealogy database after uploading the SNP profile, they are provided the same kinds of information as other database participants. Thus, for each uploaded profile, the database provides law enforcement a list of genetic relatives of the offender, identified as participants who have opted in to such sharing that is generated by the internal algorithm, and for each match to the length and location of the shared DNA blocks, as well as contact information. Notably, that person can choose to remain de-identified, but for example, they can participate but use a pseudonym. Good to know. The databases do not share with any participant, including law enforcement, the SNP profile of any other participant. Although it is possible for law enforcement to participate in genetic genealogy databases against their terms of service or via a warrant, it does not appear that either route has resulted thus far in any access to actually getting the SNP profile. If law enforcement participates against terms of service, that is, okay, right here, self-identifying, or sorry, without self-identifying as law enforcement, or for purposes other than allowed, they still participate on the same basis as other participants. And again, no genetic genealogy database gives its participants access to other S&P profiles. Again, like that's like the actual DNA profile, right? But that's not what they're looking for, right? They're looking for a name. The only known warrants, so like this, in other words, is a non-issue, they're not going to actually obtain your DNA is what they're saying, basically. So, the only known warrants that have thus far been submitted to genetic genealogy databases requested either the identity of a relative match or permission to participate in the entire database and obtain the name, pseudonym, or contact information associated with a match's account, effectively overriding the consent preferences of participants who opt out. So essentially what they're saying is, if law enforcement doesn't break the rules by doing the opt-out loophole thing, right, and they want more names, if they want to get the names of people who opted out, but they want to do it without breaking the rules, then they can, they can do it. They can do that through a search warrant asking permission to have access to the entire database. That would be the way to like lawfully do it. While it is unclear how law enforcement conducting IGG might use warrants in the future, it is unlikely that such requests will encompass S&P profiles, right? Again, it's like a non-issue. So, okay. Nevertheless, any participant, including law enforcement, can potentially infer the sequence of DNA segments via a chromosome browser tool provided by some databases. Interesting. So those browsers provide a graphical view of DNA segments. Wow. What the fuck word is this? My brain wants to say magicians, but that's not it. Bioinformaticians? That's a new word for me, guys. Recently, can we just say it's magicians? Let's pretend. Recently, bioinformaticians described how segment matching features can be exploited to uncover a substantial amount of a person's genotype via techniques that involve uploading multiple real or artificial data sets to genetic genealogy databases. Remind me who Jeff Nye is again. I can't remember all the people. Jeff Nye. Remember who that is? Oh, there it is. Thank you. His father. Oh, Jeff Nye's father. Okay, but who's Jeff Nye though? Jeff Nye's father. Okay, got it. Is a district court. Right, that's correct. Correct there, Heather. They can access the full database, but must get a warrant. Absolutely, that's right. Correct. That's right. Are you saying he's the appointed attorney? He's been appointed to be one of the extra people for this case? Because, like when they asked for more, or are you saying that's got to be what you're referencing, right? Yeah, appointed. Okay, right. So when they asked for more help from the AG's office, right? That's right. That's why I recognize the name because of course I covered that. Right. Okay. Oh, okay. Oh, okay. Right. Right. Okay. I can't picture what he looks like. So I guess. That feels like such a long time ago when they argued that. But yes, skinny bald dude. Thank you. Right. Okay. Right. Now I'm remembering. Okay. Right. Okay. He was teaching at University of Idaho. Interesting. What was he teaching? I don't think they have a law school. That's it. Interesting. what else? Was there something else I was going to say here? He was teaching law. They have a law school? Really? Huh. Okay. So, law enforcement could theoretically seek to reconstruct a person's S&P profile using these techniques, but the results would not be more informative in suggesting genetic relationships. There are also straightforward solutions to these concerns. According to experts, the hack would not be possible if testing services cryptographically signed the S&P profiles they provide to participants or exchanged data directly at participants' request. Both procedures would inform recipient databases of the source of the S&P profiles and allow them to block artificial profiles and profiles produced by unapproved entities. In addition, it might be appropriate from a public trust perspective to prohibit law enforcement from using any information obtained from these databases to reconstruct all or some of a person's genome. I agree with that. This prohibition would serve to complement the DOJ's existing ban. Right. We've read this. We read all that. Right. Yeah, that's true. It would complement that. Okay. Misconception number 2. Law enforcement will arrest a genetic genealogy database participants' relatives based on the genetic information that they gave to the database, right? Are people really concerned about that? Like, I don't see how that is rational, but okay. As described above, however, IGG is used only to generate leads. When investigators receive an anonymous phone call that a murderer works in an auto maintenance, they follow up on that tip by focusing investigative efforts on individuals locally employed in that field. Similarly, again, this is how it's supposed to go, right? Similarly, when investigators learn through IGG that a criminal suspect is genetically related to a certain genetic genealogy database participants, they follow up on that specific scientific tip by focusing investigative efforts on individuals who are within the family tree. In both cases, the tip serves to narrow the universe of individuals, right? This is why, again, you see why I said that, how incredible to think about that this is the goal of IGG, and then compare that to getting a direct match, right? Right here. The tip serves to narrow the universe of individuals, like all the humans in the universe, right? Narrowing it down from however many people to one, right? And then imagine, instead of having to do all of that, you get a direct match who might warrant a closer look in the investigation. At that point, corroborating evidence connecting the person to the crime, such as access to the crime scene, possession of a weapon, whatever, they can provide justification for their arrest and conviction. At a minimum, according to the DOJ interim policy and other IGG best practices, corroborating evidence should include a confirmed match resulting from a direct comparison from buccal swab, right? Indeed, the DOJ interim policy, which applies to every IGG agency that uses DOJ funds to conduct IGG, specifically prohibits the arrest of any person based solely on a genetic. Holy fuck, right. Now that, holy God, other God. Remember when I was like looking at that chart and we were looking at the timeline, and I was like, why would they need to distance the time, expand the timeline, right? And Heather also made a point about the cameras, but we talked about other reasons that I had been thinking of. I'd forgotten about this part. You guys, this is the biggest one of all. This is the biggest thing. Remember when I was like the whole example I gave, like pretending, like I gave an analogy, like cheating on a test, right? And it's like your new job is to come up with every way to make it look like you didn't cheat on the test. And how did you actually get the answer, right? This. Okay. It specifically prohibits the arrest of any person based solely on a genetic association generated by a genetic genealogy database. In other words, if that's all they had was, if it happened, a direct match, right? Or even if it was not a direct match, even if the impossible happened and they built that family tree in record speed and they got him that way, right? Even if it wasn't, if that is all they had, it's not enough for an arrest, let alone to charge somebody. Because remember, there's different standards there, right? Arrest first, and charging can come after. So, but even for the arrest alone, that's not enough. Wow. And right. And that's my point. And that right there would be why, again, they have to distance themselves. If that happened and they got a direct match, their new job, they being the FBI, would be, their new job would do everything you can to make it look like that didn't happen, right? And so we've talked about that at length and looked at that with the timeline, but like, that's what you see there, right? I mean, and really, they kind of got lucky too whenever Moscow wanted to take the case back, right? Because now it's their problem. And then what does the FBI? They can delete everything, right? And then they have the plausible deniability. We don't have it. We can't turn it over. We don't have it. We can't turn it over. Yeah. Right. Yep. I mean, the thing is that like we said earlier too, the IGG fight started from day one. They have fought the IGG from day one, the state, right? Like fought to turn it over, fought everything about the fight really started when you read the affidavit where they're referencing IGG, but they don't use the letters, right? Plausible deniability, right? And then when they finally started arguing about it, and then it's like, we didn't rely on IGG for the affidavit, right? We didn't rely on IGG for anything, right? Like the state says, we didn't rely on IGG for anything. It was just an investigative lead. And what does the defense say? Their entire thing is IGG. That's how they got to Bryan Kohberger. Their entire case is IGG. They're saying the exact opposite, right? And again, the whole thing is hilarious because it's a moot point because, again, technically, it's like you don't know what else to call it, so you call it IGG. But like technically, if what we're thinking is potentially true, like the direct match, again, if that's the case, there even wasn't IGG, right? It's just the use of an IGG database, but there isn't any IGG. I'm from North Carolina. Yeah, and we pull it up on almost every live stream, but yeah, we've gone through it billions of times. And in fact, a lot of the things that I pull up in those, like even the videos we watched tonight, right? Like the videos that we watched tonight where it had little blown up or zoomed in so you can see it, right? The like for example, where all the dates are missing, right? And I get pulled up those examples. All that's from the probable cause affidavit. So there's bits of that too. But yeah, for Top Cat or anyone else that wants to have it and read it for themselves, where you can find it is here. So just Google, anyone that wants to have any of these documents for themselves, Google Idaho Judicial Cases of Interest. Okay. And then what it'll look like is this. And you just scroll down. So there's a first guy here. Bryan Kohberger's case is the second case. So you scroll a little bit. There it is. And these are in chronological order. So the very first thing is there it is, the affidavit. And you can have it there. You can read and you can download it, or you can just pull it up on a browser. By the way, so here's all the filings in this case for people who haven't seen this. Just keep scrolling for another year and we'll be back to where we are currently. There we go. There we go. And then of course we've got Lori Vallow's appeal happening. So wait, did they add more stuff since before the live stream started? Hold on. No, they didn't, right? Hold on. Is this? No, they didn't add anything new. The notice of hearing was the last thing. Okay, because I refresh this thing all the time. So I was like, wait, is there something new? No, there's not. Okay, just kidding. So yeah, so that's where you can find that stuff. Yeah, you'll have to, right. It should. Copcat makes a great point. Wouldn't the affidavit go through all the evidence they have? Yeah. It's hard to really, it's unique. It's a rare gem. You just kind of have to, maybe you just have to kind of go, again, you can see on other live streams, again, it'll be timestamped where I've covered it more than 5 times probably, but or you can read it, you can pull it up, and see, it's a special one. That's all I can say. I've not seen anything like it, I will say. And if you do take a look, you'll notice when I keep mentioning the fact that there's like no dates, you'll be like, yeah, you weren't kidding. Why is that? Who else is from NC? Are there other people? And Top Cat, are you in the Discord too? Because that's another good way to share links too. But oh, hello. I think if you're new here, welcome. I will not even try to pronounce your name, but I have your comment pulled up. Well, now I want to try since I said that. Wakenyan. It's probably terrible, but welcome. Yeah, lots has happened. That's true. I missed the Black Rose issue. I don't know what that is, but are you guys having thunder snow? So anyway, but yes, Top Cat, the Discord is a really good way to share links too. I feel like you probably have already heard me say that a billion times. So, but yeah, it is a dog of a PC. That's one way to say it. That is one way to say it. No offense to dogs though. Love dogs. Oh, okay. Something from a conversation. Okay. Right. Gotcha. Okay. So, okay. So even if the perpetrator is a database participant, a prospect we view as highly unlikely. Wait. Sorry. Hold on. My brain just buffered that. Ah! Okay. No. Okay. Hold on. I can't even believe that this is what, right. Speaking of direct match possibility, right? Even if the perpetrator is a database participant, a prospect we view as highly unlikely, right? Because it's like, how could someone get that lucky, right? But remember, like I keep saying, when I did my DNA, I was like, it's a matter of time. It'll happen. I kept thinking that to myself. I didn't think it'd be this soon, if that's what happened. And the genetic genealogy database indicates a perfect SNP match. Direct STR comparison testing will be performed to confirm the match. Well, that did happen. They did do a buccal swab. Given the reliability of direct STR comparison testing when it is conducted and results in a confirmed match, it is unlikely that it will result in a mistaken identity arrest. Oh, okay, they're just addressing like a mistaken. Yeah, no one's thinking. I don't think that's something that people are concerned about. Identical. They're saying if there's like identical twins. Okay, right. Okay. That said, an innocent person might experience significant stress in the time between when their DNA is collected for direct STR comparison testing and the return of a negative result. Oh, now they're just going to talk about some movie, whatever. Okay, let's go on to the next one. So misconception number 3, IGG necessarily involves collecting and testing DNA samples from a larger number of innocent persons than would be the case if IGG were not used in the investigation. I don't know that I even understand that sentence. A common criticism of IGG draws from the fact that it can involve collecting and analyzing DNA from multiple persons. all but one who might be guilty of the crime. The argument is that such testing constitutes an invasion of privacy that undermines the ethical acceptability or even lawfulness of IGG. However, when a crime involves DNA evidence, it is not uncommon for investigators to collect and test DNA. Yeah, that's a good point, right? From individuals who are eventually cleared, right? Like, again, what do they do usually? The first thing they do is they're going to be like, okay, people that live in the house, family members, the normal protocols, right? And everybody gives them their DNA, and then they're cleared, or they're not cleared, whatever the case is. Whether or not those investigations involve IGG. Moreover, one of the benefits of IGG is that, especially in high-profile cases where the perpetrator is unknown to the victim, it potentially can reduce the overall number of such tests that are conducted. As an initial matter, it is important to understand that DNA collections generally occur in 3 investigative contexts. 1, voluntarily, with the knowledge and consent of the donor. 2, involuntarily, with perhaps the knowledge but not the consent of the donor pursuant to a warrant or as authorized by law. And 3, involuntarily, without the knowledge or consent of the donor, based on surreptitious collection of the donor's abandoned DNA. You guys know where this is going, right? Trench. In the USA, DNA collections in all 3 contexts are lawful. With respect to surreptitious collections in particular, although regularly challenged, courts have consistently upheld law enforcement's collection and analysis of shed or abandoned DNA. I guess another example too, besides the dad trash, would be like when, for example, like they've got someone in an interrogation room and they're like telling them they're not a suspect, and then they like offer them a cup of water. Here, have this nice water. Aren't you thirsty? And then they like drink it and then leave their cup, right? Could be another way. I mean, there's lots of ways, but whatever. Shed or abandoned DNA under the 4th Amendment. Even states that have adopted statutes prohibiting DNA testing without consent make exceptions for law enforcement purposes. DNA collections in all 3 contexts are routinely performed for the purposes of investigating suspects identified from all kinds of tips, not just leads generated by IGG. Moreover, DNA testing of suspects following surreptitious collection is especially common where the offender is a stranger to the victim and the DNA is the primary evidence. So like Lisk could be an example of this, right? When they got the pizza box, right? Is the primary evidence supporting the association of any aspect of the crime. What is unique to IGG, however, is the targeted DNA testing of non-suspect family members that sometimes occurs to narrow searches to specific branches of family trees. Specifically, law enforcement might know that certain individuals in the family tree are innocent. For example, they are female and the perpetrator is known to be male. This practice of targeted testing was apparently used with an Oregonian man, residing in a nursing home who voluntarily provided a DNA sample to law enforcement investigating the Golden State Killer case. Although it was reported that the man had been misidentified as a suspect, investigators told one news outlet that they never viewed him as a person of interest but sought his DNA to understand if they were focused on the right branch of the family tree. We don't need to see here anything else. They're just saying it can, whatever. Fewer tests. Okay. Cost saving, right? Whatever. Okay. Also unique to IGG are the privacy issues associated specifically with surreptitious DNA collections from relatives. Dad trash. That is the dad trash. That is literally the dad trash. Literally. Literally. Tony, if you're new, welcome. For anyone who's here, if you're new, welcome. And if you're not new, we love you. Glad you're here. Glad everybody's here. And, part of the Squirrel Crew. Excellent. Well, and that's a whole other, I still have to finish. Yeah. We delved way deep into, the business with the trash. And I meant to follow up with that and do another live stream because I had found some really interesting case law that is specific to Pennsylvania, and I've been meaning to do that. But anyway, there's a lot of considerations with all that. So, your old news, what does that even mean? Yeah, like basically, yeah, the trash, there's a lot up in the air with the trash too. The only thing is this, what it kind of, I guess, led me to is that if any, there seems a lot of ways in which that could have been not, you know, that could have been a problem. But my brain kind of ended up with, well, if any of that was the case, his defense team would have done something about that. Like that would have been like dealt with first thing, you know what I mean? So in my mind, I'm like, well, I guess, you know, but, you know, there's so many different things. There's so many different things to avenues in terms of the issues that it's, you know, like in other words, I was really focusing on delving into that, and I was delving it. And then it was like, then the motions to suppress came out. That's what happened, right? And then it's like, oh, here, look at all the other issues. So I still need to follow up and finish the topic of the trash. So glad that came up. Okay. So dad trash. The DOJ interim policy limits this activity to instances in which investigators believe that requesting a DNA sample would compromise the integrity of the investigation. And as a general matter, surreptitious collections are not favored, given that they can require more time and resources than voluntary and warrant sample collections. Compromise. Right. So in other words, you wouldn't want to go up to the dad, for example, right, and ask for a buccal swab in certain cases, right? Oops. They're going to require more time and resources than voluntary. Like, yeah, in other words, like following somebody's relative around and waiting for them to discard a piece of trash, which is like literally what they were doing in this case. Even if such collections are rare, however, the practice warrants ethical and legal scrutiny. And by the way, one of the things I pointed out when we were doing all the trash stuff is that it was interesting because when you look at the timeline of the dates that they were there, you know, they were there several days surveilling the house, right? And then you look at when they finally got the trash. We actually did some digging into this. And what we found was that that would have been trash day. Like almost positive. Like it was like, we were like almost positive. Like in other words, that was what everything showed. Like we had some people that were going on with like the community, you know, Facebook and all this other stuff. Anyway, and like, I think there was actually someone, maybe he was even local too, who confirmed that. But anyway, so what it looks like though, what we kind of figured out was like, what it looked like was like, they were surveilling, right? And waiting, like, unless somebody left the house and like, I don't know, threw some trash on the, you know, when they were going somewhere else or whatever. But basically what it looked like was potentially they were waiting, right, until trash day, when it's the day of the week, you know, how it varies in different places, but it's the day of the week that you bring out your trash cans, right? Because literally when you look at the day that they got the drag trash, that was trash day. Because we looked at the days of the week and all that, and it was like, holy shit, right? You know, which, you know, I guess that's, I don't know if it's a good thing, but essentially, you know, they are like, well, we got to wait till trash day so that the bins get put out, right? So it's not on the curtilage. Although there's other issues, even if that was all done. So, but anyway, So what they tested, great question. That's another thing, right? They have never actually said what the item was. They've never actually said what the item was from the trash. We just know that they got something from the trash can and they tested it, and it was in other words, it was the dad trash. It was Bryan Kohberger's dad's DNA. Because it was not a direct match to the DNA from the crime scene. But it was like really super fucking close. So it was his dad, right? And of course they were hoping for his DNA, an item with his DNA, but we don't know what the item was. The irony too is the fact that they maybe wanted his DNA instead actually end up with his dad's could be the closest thing, in terms of anything related to IGG. Not that it is IGG, but just at least it involves a family member or a relative, right? What are you referencing here, Heather? How if DNA is left at a crime scene? I don't know how far behind that comment was. Yeah, paternal match. Thank you, Heather. Yes, that's correct. Well, and we covered this. The different documents say different things. It's maddening. I pulled up on one of the live streams all the different documents, every single one back to back, where they mention the trash, and the documents all contradict each other. Even honestly within the way the defense describes it, there's differences. Sometimes it says things like came onto the property. There's other times where it references it and says I can't remember exactly. They describe it in other words, there's times where it's described like as if it's out on the side of the road, right? And then anyway. So and the curtilage, by the way, is the property. Curtilage is bad. You don't want it on the curtilage. You want it away from the curtilage. Curtilage is bad. If I'm reading this correctly. Like, yeah, if that makes sense. Like, in other words, you want, once you pull it out to, for it to be collected, right? Then you're not curtilage. It's fair game. Well, if it's a public road, which is another thing we've talked about. If it has to be a public road. Anyway, no, he did not live with his parents. He was home for Christmas, Top Cat, because he was a student at Washington State University, which, Idaho, where the homicides were, right? It's just over the border. Like, in other words, where the University of Idaho is, and then where like Washington State University is, I think it's like 10 minutes apart or something. And you cross the state line there. And then his parents lived in Pennsylvania. So he was home for Christmas when they arrested him and everything. And then I'm noticing Heather already answered that question. Thank you. Curtilage is fair game. Did I get my wires crossed? Hold on. No, I don't know. Hold on. Yeah, Heather's on it. And again, we delved into the data community thing. We looked it on that live stream with the trash. We looked up the difference between an HOA and a gated. We looked up all of it. We Google mapped it. We did the field trip. We looked up all the laws. We found the specific there. I even went so far as to try to find the specific private trash company that would service that. And I couldn't find the exact one, but I actually, like, that's how close I was to getting to, like, trying to crack that whole thing with the trash. Was like, here's the actual place that would have been getting the trash, right? Anyway, but So yeah, so no, I did not get my wires crossed though. I don't know why you're saying curtilage is fair game, Heather. It shouldn't be. I mean, that's in the federal rules. Like, I don't think there's any way. And part of the reason is because the distinction too, in terms of when it comes to like, well, this is relevant to not just the trash, but other things, but like the test in terms of like, when you look at the case law, right? The test is like, is this a place where the person who's living somewhere would reasonably expect the public to have access, so that like people walking down the street or whatever, just the public would have access to such and such area, right? So the curtilage being, is like, in other words, here's the deal, right? Why does that matter? Because in other words, your rights in terms of search and seizure don't just pertain to like your house, like your indoor environment. It's that has been expanded to include the curtilage being the area around the house. So your yard, right? Your backyard, your front yard, and any any outbuildings. So shed, garage, things of that nature. Also protected, right? In terms of being part of the curtilage, right? They need a warrant. That's the point. They need a warrant. Right. And that's exactly the point. So it's considered discarded. And that was why I gave you that example of like, for example, when there's a great episode, the show Curb Your Enthusiasm. Okay. Right. If anybody's watched that show, Larry David is walking in his neighborhood and he's eating an apple, and he finishes his apple and he's got the core, and it's like trash day. Right. So like one of his neighbors has the bins out, and where he finishes his apple, and because that bin is right there, like next to him where he's walking, he opens the lid and he chucks his apple core in there. And then where it gets funny is because the person comes out and gets really mad at him. Now, of course, they don't engage in a legal discussion. So in other words, the person living there is like, hey, you can't do that. And I don't remember what happens from there, but legally he did nothing wrong. That's allowed. And again, because public access. So that's why I use the example of like, when you bring your trash cans out to the curb, right? People who are walking up and down the street you see what I mean by that? That's why that's kind of a good test. But you wouldn't expect them to venture on into your yard. That would be weird. Top Cat is new to the case. Yes. And Top Cat is in Australia, by the way, too. But yes, she's getting caught up asking really good questions, which is awesome. Yeah, you don't have to apologize for the questions. Yeah, Heather, again, I've covered literally all of the statutes and stuff, but I have found some additional interesting case law that I haven't covered that I've been meaning to. Well, I mean, again, if you guys go back and watch those other live streams, that you look at the thumbnail, it'll have trash in the description, right? In the title. But like, basically, another thing that's interesting is the research that I was doing showed that road where his parents live on is a private road. Interestingly, it looks like not all of the roads in that neighborhood, in that community, are private. Some are private and some are public. And what it looked like was the neighbors like directly beside them, actually their road. It's one of those things where it's like the road is, so if it's a private road, right, it's like that road only they live on, right? So the neighbors, some of them have public, but from what I saw, like Bryan Kohberger's house where his parents live anyway, that road is private. Which is when I had another interesting thought because of that, which was, like if there's anything about throwing trash in the neighbor's bin, I thought that's interesting too, right? Because that things could get interesting there. But anyway, it doesn't look like they pulled any trash from the neighbors. But But that was what I ended up with essentially was like, well, I mean, here's the thing. Like, if that's a private road, no go. It doesn't matter if the trash is out at the curb. If the road is private, nope, not fair game, right? So. So yeah, but yeah, you guys, wouldn't it be weird? Like, imagine like if somebody like walked onto y'all's prop, wherever you live, right? And like, everybody's going to have a place where it's like, if somebody's walking out there, like in front of your, wherever you live, it's like, that's normal. But if they walk a little bit close, it's like, wait, what's going on? Right. Unless they're like, almost like dropping off a package or they're invited or something. Right. But in other words, just random people, the public, the general public. Right. Oh yeah. No, I mean, absolutely. I love case law, big fan of case law here. And I also love that, the laws vary state to state. I mean, I cover a lot of cases and I've covered a lot of cases and trials and in many, 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 many states. And that's one thing that I've started to collect in my brain is figuring out the differences to some of them I have kind of, memorized, if you will, from where there's cases that happen. I mean, Florida is a good example, right? Because there's so many out of Florida, but yeah. But yeah, there is, again, I want to make it a separate stream and we can follow back up with the trash stuff because I had to do quite a bit of digging, but I found some really interesting case law that was on point. Okay. And it dealt with the specific issues with like the private road and like the HOA and the gated community and all this stuff. And so I have those saved for whenever we finish up with the trash on another live stream. But yeah. So, okay. So let's continue on here. So finally, concerns have long been raised about the retention of DNA in informal genetic databases not subject to regulatory oversight. While these concerns are not unique to investigations involving IGG, they are especially salient in such investigations, given that the conduct of IGG might encompass DNA collections from relatives who are known innocents. Although the DOJ interim policy provides for the destruction of all reference samples, which we know that was referenced, right? They destroy the SNP. That's required. It might be necessary for policymakers to intervene on the specific issue to ensure uniformity of practices for the protection of these third parties. Okay, misconception number 4. IGG is or soon will be ubiquitous because there are no barriers to IGG that limit the cases in which it can be conducted. Finally, some have described IGG as a dystopian tool for state surveillance. The suggestion is that genetic genealogy databases will soon be, if not already are, consulted by law enforcement agencies in the investigation of every crime, from serial murder to petty theft. Although we share concerns about scope creep, there are currently a number of technical and practical barriers to IGG, as well as emerging policy barriers that serve to temper them. Shout out to Maryland for that, by the way. Maryland paving the way for some legislation. First, the genealogy step of IGG, that is the process of building out family trees based on genetic relationships, serves as a significant, actually, let me back up, right? Again, this is why I keep saying like IGG in scare quotes, right? IGG, that is the process of building out family trees based on genetic relationships. There you go. Serves as a significant practical barrier to the widespread conduct of IGG because it is expensive and requires specialized support. Specifically, the genealogy step must be conducted by individuals skilled in the genetic genealogy and can take months to complete, depending on the complexity of the relevant family tree, sometimes without resulting in a useful lead. Oh, by the way, for Twizzlestick and anyone else who is in Idaho, y'all might not have been here, but I asked a question earlier and you guys might know the answer. Do y'all know if for a fact, if specifically the FBI office in Idaho does their own IGG work, like conducts that in-house, like themselves, the FBI. Because for that to be the case, it's like it would kind of be a big deal. Like they would have to have like funding, and they would create like a new office for it. It would be like a whole thing, right? Do you guys happen to have any insider knowledge as to whether or not, you know, the FBI in Idaho has that? Love to know. Factors that increase the complexity of this work include the number and genetic distance of identified relatives, immigration events, misattributed parentage, unrecorded adoption, surname changes. Okay, yeah. To date, more than 96% of US-based S&P profiles are opted in. Oh, interesting. So I was wondering this earlier. I was like, I wonder how many people are like opted in versus opted out, right? But this is in 2021, right? But at that point in time, this is more than 96% of US-based S&P profiles are opted in. That surprises me. Does that surprise you guys? I figured that most people would not be. That's wild. Oh, but it hasn't had an opt-in default. Well, okay. Conversely, approximately 30% of public S&P profiles are currently opted in on GEDmatch, which opted out. So in other words, when they make, well, this makes sense. If it automatically opts you in, people don't pay attention. So that explains it. But then if you're automatically opted out and then you have to choose to provide it, right? Then the number obviously changes. So in that case, you've got 30% opted in. Although 83% of now GEDmatch users are opting in to law enforcement matching, it is well known that the overall reduction in relative matches available to law enforcement on GEDmatch has impeded the ability to successfully conduct IGG. Okay, yeah, and then if you're okay. Further, if the offender is believed to have recently immigrated to USA, agencies might decline to conduct IGG given the difficulty of reconstructing family trees using foreign records. Oh, why did I think? Oh, I see. Oh, right. Okay, gotcha. Thank you, Heather. So, right. I guess I assumed Idaho because, you know, going to the hearings and stuff. But yes, okay, thank you though. Oh, near DC, cool. Right, and again, we said this earlier in the stream too. We literally pointed that out. We had, yeah, but again, it's IGG, but it's not IGG, right? That's why it's funny. Like, yeah, hopefully you guys hopefully know what I mean. Yeah, so these are places that have, right. Are you saying these are places that have their own IGG? Right. That what if that's what you mean, that is what I also remember seeing something like that. But like, so because when I looked into it, like it seemed it's a rarity, right? And that's why I'm asking, because I mean, the thing that's funny though, right, is like it seems like that would be it would take a lot of guts, right? Like if you're the state to put it in so many documents. I mean, so many documents, right, about the FBI. My favorite one that I've been quoting now since the other day is the quote from the state's reply to the defendant's objection to the state's motion for a protective order, where Prosecutor Santa says that the FBI went to work on building a family tree. And I just think of Snow White and the Seven Dwarfs song. But anyway, but it's in so many documents about the FBI building the family tree, right? And so that's why it's like, but FBI doesn't even do that? Like, I don't know, man. It just seems like, I mean, I don't know. And it's funny because I don't think I've heard anybody even like, you know, I mean, again, the list of issues is so long that you can't point out everything. So, you know, I get it. But like that seems like a big one, and it seems like pretty, you know, obvious too. So, but you know, again, I say that like, as we know, the FBI makes it difficult to find certain things out too. So, you know, you got that whole, oh, we just deleted all of it. Sorry. So, but even if an agency has the resources to conduct IGG in a particular case, and the chances of finding a genetic relative of the offender are high, given their presumed genetic ancestry, it's still not might be possible to conduct IGG because the quantity or quality of the forensic sample does not meet minimum standards to generate a database compatible high density S&P profile. Okay, this part is not nearly as relevant to what we're discussing here. Finally, the DOJ interim policy, as well as best practices endorsed by the California District Attorney, prosecuted the Golden State Killer case, and blah, blah. And they're advised to limit the conduct of IGG to the identification of human remains and investigation of violent crimes where reasonable, again, you guys, y'all, where reasonable investigative leads have already been pursued. I've been saying this the entire time tonight, like how normally it's a last resort. That's when it's normally used. Last resort. Shit out of luck, like I said earlier. But not only that, it's mentioned as a best practice in the DOJ interim policy. And again, the fact that it was what, like, again, there's no date because there's no dates anywhere with this case, right? But looking at it, it's pretty much immediate, right? According to the state, before they ran DNA through CODIS, they sent it off to Othram. So that is such a problem in my estimation, right? Like that's, I don't know, whatever. So many things. Okay. In addition, as discussed above, investigators cannot conduct IG until they have, well, keep reading, Chelsea. Fucking hell. Until they have first conducted a CODIS search. Now, here's the thing. We saw this visually in, where is it? We saw this visually here, right? Remember we were talking about this, guys? And I was like, yep, because step one, right? Step one, CODIS. We saw that visually. But tell you what, it's another thing to also, in addition, have it in writing. And then remember, this is from the state's reply to the defendant's objection to the motion for a protective order. This chart was done by the state. I added, of course, the highlighting and like these bullet points at the top and this little circle. But anyway, so this is the chart though from the motion or the reply to the objection to the motion, right? This is what the state says. This is what the state says. And in the circle, right? That's CODIS. And at the bottom on the left, and you look at the flow chart, again, just to point it out, right? According to the state, they sent DNA to Othram before they searched CODIS. Okay. These policies serve to limit the cases in which IGG is conducted to those that are considered public safety and criminal justice priorities where other investigative tactics have been attempted or failed. Again, also that also didn't occur here. So it was the first thing done. It was the first thing done. Y'all. Of course, these barriers are not static. While the genealogy work associated with IGG is arduous and will likely continue to require specialized expertise for some time, advances in DNA extraction and testing should improve the ability to successfully generate S&P profiles from forensic samples. In addition, policy landscape will likely change over time. Please, I hope it does. We need some rules. As IGG evolves to encompass whole genome sequencing data, and as databases modify their tools and services, some existing barriers will disappear as new ones emerge. Regardless of these changes, genetic genealogy database participants are themselves the ultimate check on the indiscriminate conduct of IGG. If they disagree with changes to how law enforcement conducts IGG, including its participation in databases that have adopted terms prohibiting IGG, they are free to withdraw their data. That's a good point. I didn't even think of that, right? That's a good point. The people, look at this. If there's fuckery, guys, if there's fuckery, the people can be the ultimate check on this, right? By withdrawing their data. Delete. What a great point. The mass exodus, in turn, will render the databases of limited value to law enforcement. Yup. Yeah. The whole thing about when I kept thinking about, like, I wonder how many thousands and thousands per day of people are uploading their DNA. And then that, again, that just is going to make it quicker and quicker. And eventually the more people, it's like the quicker you get to a close family member, right? Or a direct lead, right? Direct hit. The reverse is true. You know, if 500,000 people deleted their shit off of there, they'd be fucked. No, I mean, but having said that, not just law enforcement, but even consumers, right? People that want to find a family member, like, you know what I mean? It's just, you can't conduct it, right? You have to have people for the dream. But that's really interesting to think about, right? Like if they don't, wow. For this reason, yeah, the success of IGG depends on robust participation. There you go. For this reason, the conduct of IGG in ways that participants perceive to be unprincipled or unbridled is not in law enforcement's interests. So they would not want people learning, for example, that they can backdoor it, right? Or violate the rules. All the shit we've already heard about. But this is the reason I'm glad that this was in here is because that's important to remember that even if you've opted in, like you've done your DNA and you've opted in, you can still withdraw your DNA. I guess you could also choose to go back and opt out, right? You know what I mean? But like, in other words, it's not like by opting in, they already have your DNA and you can't recant that decision, right? You know what I mean? Like you can still recant that decision. Whether you're opted in or opted out, you can withdraw it. And then that's it. Shit out of luck. Looking ahead, by clarifying the steps of IGG, including how it does and does not depart from traditional investigations, we hope to help distinguish concerns about IGG that are based on misinformation from those that are grounded in how it is currently conducted and its results are used in practice. To be clear, we have concerns associated with the certain practices associated with IGG. We view as ethically troubling the practices of conducting IGG and genetic genealogy databases without or against their terms of service, right? Yeah. Or identifying genetic relatives by name in a search warrant. Again, if there was a direct match, then that's not even a concern in this case. But the state, yeah, anyway. We favor descriptions of IGG that state the information provided to law enforcement is a list of genetic relatives of an offender among genetic genealogy database participants and their estimated relatedness. Not participants. I don't know. I don't even know what that's referencing here. They're just saying it's using different languaging here. They're saying they don't like that they're called informants, which is funny because we know that's been in some of the documents, right? That's the same as an informant. Yeah, they don't like that languaging. Identifying an unknown source with the help of relative match information is an investigative activity performed by persons skilled in genetic genealogy, can continue for months and is not always successful. Criticisms of IGG often include privacy concerns related to surreptitious DNA collection and testing. So, but what they mean, so again, usually we're referencing dad trash with this, but what they mean here in this context is that, like, because you've submitted your DNA to a database, people could actually get access to your DNA, right? That's what that means. This is not meant to suggest that privacy concerns related to surreptitious DNA testing or collection and testing are unfounded. There's concerns as they relate to targeted testing in particular are compelling. Rather, the point is that they would be more effectively addressed at a policy level. Yeah, far broader than IGG, given that even a complete ban on IGG would not eliminate this practice. Okay, so yeah, what they're saying is, like, to the extent that there's concerns about the surreptitious collection, right? It's like saying that there would have to be another way to address that, because even if you ban IGG, they'll still take your trash from the curb, right? In other words, yeah, it was in there earlier, right? It's like, they're like, yeah, this happens all the time. So, like, that's not going to solve it. Yeah, that would have to come from they'd have to make that have to become a new law. That'd have to be done through legislation. Oh my God, legislation. Just that can't happen. So, so that is the end of that article. But there's one other thing I wanted to look at. Yes, I will put the link for the Discord in the chat. There is mention of a Discord. There we go, Nightbot. Thank you, Nightbot. So, and it, you can also, if you have Discord already, you can also just do a search for Law Squirrel and look for the Squangwin. Because one time somebody did that and they said there's also I'm not the only one, there's another Law Squirrel channel, which I find hard to believe, but if there's more than one, look for the Squangwin. That's really funny. So welcome for anyone else who's new again. Deb, I suppose. Deb, welcome. Just found that's really funny that you just stumbled upon here and know people in the chat. Isn't it fun when that happens though? I freaking love that. And what is the passport thing? I'm just trying to look through, see what you guys have been saying here. Awesome. Excellent. Happy that that's awesome. Yeah. Squirrel Crew is the best. We love it. We love the Squirrel Crew. We have fun. And we have lots of silly things. So, okay. So Heather, to you, my dear friend, Heather. Okay. Would you like to take a look at this? We can. I thought it would be interesting. So this is Idaho. This is the statute for I guess stalking. Where is it? Yeah. Okay. Or it's the code rather, but same thing. Same. Okay. I always love looking at the elements of different statutes or codes, or yeah, I love this. This like makes my brain happy. Okay. So in Idaho, stalking in the first degree. So a person commits, let me get can I zoom in? Please. Excellent. Okay. A person commits the crime of stalking in the first degree if the person violates section 18-7906 Idaho Code and no. sometimes, things oh my God, have a mind of its own. All right, that's going to be yellow. That's what's going to happen. Okay. All right. And so, well, it's funny because this essentially is going to explain what will constitute them having done that. Okay. Or no, if they violate section 18-7906. Okay, wait, let me back up. All right. So we need to go out of order. What are you doing? Okay. Look, they have to first violate section 18-7906. That's the next one. Why are they out of order? So let's do that first because that's the and. Okay. So, oh, I see. Stalking in the second degree. All right. So a person commits the crime of stalking in the second degree if the person knowingly and maliciously engages in a course of conduct that seriously alarms, annoys. You're joking. What? That can't be real. Annoys? I don't think I've ever seen that anywhere in anything. I mean, maybe like in like a civil, complaint or something. But I mean, wow. I mean, seriously alarms, that's valid. Annoys or harasses the victim and such as would cause a reasonable person substantial emotional distress. Okay, questions. What? Forget the alarming and harassing. Let's focus on the annoying part. Y'all, what would remember, we have to think about this from the law, right? So the reasonable person standard, right? What do you guys think, if you're going from that, what do you think would meet that criteria? That a reasonable person, what would be the thing that is annoying enough for the reasonable person to cause them substantial emotional distress? What conduct that would annoy someone, a reasonable person, enough to cause them substantial emotional distress? I need suggestions, big time. That's funny. Thank you, Heather. Yes, I didn't see that. And yes. I don't know what people are confused about, but we're still going to cover these and go through it. I mean, so does anybody have any suggestions though? What is the thing that would be annoying enough that it would cause a reasonable person substantial emotional distress? Like poking someone repeatedly, like poke, 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 or like, oh, I know. Actually, I think I might have an example. The thing like kids do it, but also Michael Scott does it in The Office, where they just repeat the question, literally. Whatever they repeat what the other person says, literally, just like, I don't know. It would have to be for enough time, for a long enough period of time to meet that reasonable person standard. I don't know, an hour of that maybe. I could see that maybe being the thing. So but remember where we are here is they aren't they're not a stalker yet here, right? We're determining what is the definition of the stalking behavior. And so we're only on the first subsection here, right? But in other words, remember, so if we were boiled down, a person commits the crime of stalking in the second degree, they knowingly and maliciously, and then I'm focusing on this annoying part, right? Annoy the reasonable person, enough to cause them emotional distress. So it has to be a behavior that in and of itself, the annoying behavior would in and of itself cause emotional distress. Tony says, I'd be flattered if somebody stalked me. That's really funny. Okay. So, all right. Okay, anyway, or engages in a course of conduct such as would cause a reasonable person to be in fear of death or physical injury, or in fear of the death or physical injury of a family member. Yeah, I mean, that seems normal. Like that's, as used in this section, course of conduct means repeated acts, okay, of non-consensual contact. Okay. So like repeated acts of being annoying, right? No, just kidding. To the victim or family member or household member of the victim. Provided, however, that constitutionality protected activity is not included within the meaning of this definition. Family or household member means, well, do we really need, well, yeah, we have to define it, of course, right? A spouse or former spouse of the victim, a person who has been married, or wait, sorry, a person who has a child in common with the victim, regardless of whether they have been married, a person with whom the victim is cohabitating, whether or not they've been married or have held themselves out to be husband and wife. So like, I guess a roommate, right? And persons related to the victim by blood, adoption or marriage, a person with whom the victim is or has been in a dating relationship, person living in the same residence. Yeah, roommate, right? Non-consensual contact means any contact with the victim that is initiated or continued without the victim's consent, that is beyond the scope of the consent provided by the victim, or that is in disregard of the victim's expressed desire that the contact be avoided or discontinued. So for example, you've got the person who's just repeatedly doing the thing where they just like repeat what you say. Like you ask them a question and they just repeat it back, and then you no, but really, I'm not kidding. And then they repeat. I don't know. All I can think of is the Office episode, but and let's say that goes on for 30 minutes, right? And then you're like, my express desire is that you stop doing it, but they continue. Then that would count, as long as it's causing you emotional distress, right? Okay, non-consensual contact includes, but is not limited to, following the victim or maintaining surveillance included by electronic means on the victim, contacting the victim in a public place or a private property, appearing at the workplace or residence of the victim, entering onto or remaining on property owned, leased, or occupied by the victim, contacting the victim by telephone or causing victim's telephone to ring repeatedly or continuously, regardless of whether a conversation ensues, sending mail or electronic communications to the victim, or or placing an object on or delivering an object to the property of the victim. Victim means a person who is the target of a course of conduct. And then there's the punishment for stalking in the second degree. Excellent. So then, now we go back. All right. So a person commits stalking in the first degree if they've already violated what we just went over, stalking in the second degree. And that's the key part there. And the actions constituting the offense are in violation of a temporary restraining order, protection order, no contact order, or injunction, or any combination thereof. So like, for example, all right, to use the example I've been giving, you got the person who's just repeating the questions back and all that, right? 30 minutes go by, you've asked them to stop. You're like, I'm emotionally distressed. My express request is that you don't do that. And they keep doing it, right? And it gets to the point where it's, you have to go get some sort of restraining order, right? Or protection order. And then sure enough, they continue, right? With the annoyance. Okay. Then that would be first degree. So yeah, so they, so in other words, yeah, so they are in violation of the order, or the actions constituting the offense are in violation of a condition of probation or parole, or the victim is under the age of 16, or at any time during the course of conduct constituting the offense, the defendant possessed a deadly weapon or instrument, or the defendant has been previously convicted of a crime under this section, or section 18-7906, which is the second degree, previously convicted, or substantially conforming foreign criminal violation within 7 years, notwithstanding the form of the judgment or withheld judgment. or the defendant has been previously convicted of a crime or an attempt, solicitation, or conspiracy to commit a crime involving the same victim as the present offense under any of the following provisions of the Idaho Code, or a substantially conforming foreign criminal violation within 7 years, notwithstanding the form of the judgment or withheld judgment. So in other words, like how it said, if you've previously already been like convicted of the stalking, right, and you do it again, but also if you've previously been convicted of other crimes, administering poison with intent to kill, kidnapping, all this stuff. And then it's just saying the definitions are the same as in the second degree one. So yes, that makes sense. Okay. So stalking in the first degree is punishable by no more than 5 years prison time. Yep. Yeah, correct. And did we talk about this? I feel like I maybe put this in the chat yesterday, but yes, a civil protection order is initiated by the victim. Correct. Yes, and a criminal protection order is sometimes initiated by law enforcement after finding probable cause for arrest. Right. Or I might be thinking, yeah, the other thing too is that I was saying, I think this was last night too, was like that, like for civil, right, it's going to be focused more so on the taking act, like the victim's, actions, right? Like, and then criminal is going to be more focused on the person committing the action. So, and it is funny. The drones is that's a whole other thing too, right? With drones, because like, that's another one where the law is trying to get caught up with, So Heather's saying there's no state in the United States that requires a victim be aware and in fear. Right. Yeah, no, of course there isn't. Right. Yeah, because the thing is that, again, in order to meet the elements for stalking, right, it's not assessing the behavior of the victim, right? That, again, like I said, that wouldn't make any sense. It's assessing the behavior of the person who's committing whatever a crime is. But if it's, in this case, if it was stalking, it's not about what the victim does or what the victim feels or what the victim thinks. It's about what the offender did, It'd be like a good comparison would be this. Like, imagine if like you see like first degree murder, right? And imagine if it was like outlining the elements of first degree murder, and it's like, the victim needs to have died. Well, we know that with murder, someone has to have died, right? But the difference is this, that it's not about what the victim needs to have done. It's about, like, when you look at any statute, right, it's going to say it's about the person who's, whoever it is, the defendant, right, suspect, like knowingly and intentionally caused the death of another person. It's about what the person does, who committed the act, right? So it wouldn't make any sense to be the other way around. "15-minute," I don't know what 15-minute cities means. But yeah, I mean, with drones, as with anything, the legislation is just woefully behind, right? But I will say they have more with that. There's more there with drones than there is with IGG in terms of both case law and legislation. But again, the drones, I guess, have been maybe around longer. And not that IG hasn't been around longer, but in terms of people, like it's been, we covered in a different live stream an article about this where it's been around, but no one paid any mind to it. And in the article, they discussed how that's what makes it so potentially dangerous, because nobody paid any attention. Like it's been around, right? But nobody and there was just people doing it, hobbyists, right? But by the time it sort of got more traction and people started hearing about it, and anybody was using it for anything with like law enforcement, right? It's like by the time any of that happened, it had been going on, and people have been submitting their samples, and like now it's like, what was the word that they used? Like, I can't remember the description exactly, but it was like, by the time you've noticed it, it's too late. Like it's already like, it's already a huge thing, And again, because it relies on people submitting samples, right? That's the whole thing. Like IGG lives and dies on people participating. So, I don't remember where I found that, but it's on another live stream. Of course. So I'm just wondering, Heather, like I'm trying to read between the lines. So the reason that you brought all this thing up with stalking, did somebody did somebody imply, I guess, that the requirement for stalking means that the person being stalked needed to like A, know they're being stalked, B, be afraid, or I don't know, anything, like, right? Because like that makes literally no sense. Even if you don't even get into the elements, right? It makes no sense because people can be stalked and not know they're being stalked. It happens all the time. So don't tell me that's what somebody said. I will die. I will fall over. And someone will have to take care of Frodo. I'll fall over and die, and Frodo will be without a mommy. Frodo's my dog, by the way, for anyone who's new. Bye, Top Cat. I hope you have a wonderful day. Thank you for being here, as always. Don't tell me, please. That doesn't make any... I can't, though. Well, I don't know who these people are. This is why I'm glad I'm not around those people, because I couldn't handle it at all. I couldn't handle it. I mean, there'd be an easy way to just be like, I mean, just off the top of my head, the number of cases I could list where there was somebody who was being stalked and they didn't know it, and then they were subsequently murdered, just that alone, right? It's like, we'd be here all day. I don't really understand how anyone could even think, like, again, even if these people who are clearly not the most smart, like, even if they don't know anything about, like, you can leave the statute out, just go with common sense. Like, okay, what am I saying? All you need to thwart that is common sense. You don't even need to get into it, because they're never going to understand what we're looking at here, right? Clearly, just go with common sense. Maybe, and you can shut that down in a second, in my view. Like, I don't know. I guess it didn't even occur to me that anybody would say that. So that's why I was not sure what the issue was. But yeah, because that just doesn't, I don't know. I don't understand. I'm still trying to wrap my head around it. Like, another great example, you know, sometimes analogies work well with people that are like that. Maybe, I don't know. Again, you could do an example like this, right? Okay, here we go. So let's say you've got someone who is like a paraplegic, okay? Like they don't have any feeling. Let's just use the example of a leg. Someone that has they can't feel anything in their leg, right? So they have no way to feel pain in that leg. And let's just say that another person comes over and like takes something, some sort of weapon, they shoot them in the leg or they stab them in the leg or anything to the leg. And let's just say, so then the person doesn't feel any pain. By the people who apparently have that type of incapability of logic, if you go with that, then it's like, well, that person can't be charged with a crime. I mean, there's got to be an even more obvious example where it's like, surely if you gave them that example, they'd be like, well, no, of course not. And it's like, well, then yeah, same thing. If that makes sense. Like, I mean, another example could be somebody robs, so you got a rich person, right? Someone's a rich person and they have like a pile of gold and somebody, or I don't know, they have a pile of cash, whatever. And somebody robs them. And let's say they rob $10 million, right? But let's just say that the person doesn't notice because they weren't home or they have so much money, whatever, I don't know. That person still would be charged with robbing. I mean, there's so many examples. One could come up with a lot, right? But I think the first one maybe is even better, right? Like if you attempted murder, great example, right? Attempt to kill, because you could even say like take the person again if you say they have no feeling in let's just say they have no feeling in their throat. Let's say they have no feeling in their throat, and you slits the person's throat, attempting to kill them, right? And you know, the person didn't feel anything and they survive, right? Still get charged with attempted murder, right? Yeah, I don't know where you're encountering this, but maybe you need to stay away from those people. I mean, it's concerning, really. I don't know. That's concerning to me. It makes me wonder if it's an argument that people are making for some other reason, right? Like it's not rational. It just makes me wonder if maybe it's like they're trying to prove a different point, and that's why they're taking that stance, because that doesn't make any sense. Does that make sense what I'm saying? Like there's a different issue, right? Because there's either that or I just don't know how someone could be that dumb, like, you know, just to be blunt, like I just don't. So, and if that's the case, then then by proving that if that's the case, you have to figure out what the other issue is, because you're not going to be able to get anywhere with proving that what they're saying doesn't make sense. Whether you go with a blatant or obvious example, or whether you go with here's the statutes, here's the, you know, code, you're going to have to figure out what the actual issue is, because yeah. That's interesting, isn't it, though? You know, some people struggle, I guess, maybe with like assessing or reassessing things. You know, instead of changing their mind about something when they get new information, they then try to bend the information so that they don't have to change their mind. And that's when you end up with a lot of things. You just end up with like logical fallacies, or things like people like confusing the issue, right? If that makes sense. Oh, are they people still okay? Because of because of Prosecutor Santa saying that. So I don't know what people are saying, but here's what I will say. That here's how I interpreted that. That okay, colloquially, right? Colloquially, for the layperson, there might be how people call something stalking. Let me give another here. Here's an example, right? In a different realm. Like, okay, like for example, how people throw the term around, like people throw gaslighting around, or narcissism, right? Where it's like, oh, that person's a narcissist. Whereas like if you're a psychologist, right? You're like, well, hang on, be careful, because like that's an actual personality disorder, right? You know what I mean? Like, so like if you're in a certain field, there's words that maybe are used by everyday people, but they mean something else for everyday people that they mean to the person in that field. Okay. So stalking has, people can say it as a joke. Oh, that person's stalking me. You know what I mean? Like, I don't know, there's lots of ways but then there's also the legal definition, as we've just looked at, right? Even if you don't take into account how things vary by the state, even if you don't take that into account, it's like there's a legal definition and there's also just like a non-legal definition, how people might use it every day. And that's subjective. And that is unregulated. That's freedom of speech. That doesn't actually mean anything, right? So my read on it was that, and it kind of goes along with the plausible deniability thing too, right? That when Prosecutor Santa said the thing about, or I think it was him, right? The thing about the not stalking thing or whatever. It's one of those things that's like, that was said as in, they're not charging him with, where is it? When you look at the indictment, right? 18-7905 is not on there, right? Neither is 18-7906. It's not part of his charges, right? But instead of saying the code, if Prosecutor Santa just says stalking, or whoever it was, right? So it just says stalking, right? They will know that people they will know that the other parties, right? And in the legal, like, they're going to be like, oh yeah, you're talking about the offense, right? But also they'll know that the lay people and the people watching on TV and the people, whatever, will be like, will interpret it in a different way. Or whether they know that or not. That's what happened. That's what happened. That's what happens and happened, right? And again, like it could have been more clear by giving like the actual violation number, or even just by being clear and saying it. But oh my God, stupid thing. But by literally, that's why I feel like it must in a way have been on purpose, just so that lay people could take it a different way, right? Because to literally only just say stalking, again, to the lay person, that could be whatever you interpret it to be. It's completely subjective. Does that make sense? I couldn't agree more. So again, I still don't know if I'm pronouncing your name correctly, but Wakenyan, the negative publicity is pretty much guaranteeing a potentially innocent person convicted to the death penalty. Nobody should ever have to face the death penalty on a circumstantial case. Yeah, I mean, and I just my own personal thing. I don't think there should be death penalty, period. So I definitely agree. Oh, that's interesting, Heather. So, I mean, even if somebody, okay, that's interesting. So even if somebody interpreted it in the legal sense, my interpretation of when Bill Thompson, I think it was him, prosecutor Scanner, said that, again, it's like, I think what he said was something like, we're not saying he's stalking or whatever, something along those lines, right? But like, or we never said that. Like, what I translated that into, he's not being charged with it, or we haven't charged him with it. In other words, it's not even to say that he did or no one did or didn't. It's like, in other words, that's not the issue. It's like, whether anything happened or didn't happen, I don't even think is what was going on there. I think literally it's like, it's not part of the charges, right? That's how I interpreted that, if that makes sense. Oh, I see what you're saying. I see what you're saying, Heather. Okay. Yeah, no, that's bizarre to me. I see what you're saying. I see what you're saying, Heather. You're operating under the assumption that the state would have charged. Okay. I see what you're saying. I will say this though, just to keep this in mind. When you look at the app, like when you look at how well they did proving like the charges that they've already gone with, right? Like when you look at the affidavit, right? Everything we talked about, when you look at all the stuff we talked about tonight, right? And you look at all the mess they have on their hands, like in so many ways. Again, like another thing too, right? Like CODIS out of order was just another one. I mean, the list is so long, and it's like this whole charade, the whole charade with the IGG, all of it. And you look at how effective, let's say, they have been at doing their job correctly with what they've already charged him with. It's not out of the realm of possibility that they, had their hands full and didn't, I don't know. I'm just saying, in a way, like, in other words, like if you fuck it up just as badly with like a whole other different set of charges related to something else, like, will it just draw attention to the incompetency? I don't know. Does that make any sense? To where it's like, we're better off just sticking with like it's a death penalty case, 4 homicides. Like, I don't know. Like, let's not risk it by adding more things on that we can fuck up, I guess is what I'm saying. Right. I know. Right. I agree with you on that for sure. Agree. They need to do better. Definitely. Yep. Oh, so I see what you're saying, Heather. Yeah. That's right. I see. I was actually editing what I thought maybe they were implying to make it less dumb, wasn't I? Okay, that's funny. Wow. Yeah. So, right. The surveilling is in the statute. Yeah. Well, I don't know. You know, I mean, but to this end, though, it's similar. Like we were talking the other night about the using the word placed about the knife sheath. We were talking about that, right? Like that is one thing that I can say. I did see people freak out about that in certain chats and stuff, like when whatever that was in, and it used, you know, the knife, whatever, the DNA, the knife sheath was, what did it say? The knife sheath was placed wherever it was, right? Something like that. Used the word placed. And everybody freaked out. And I was like, oh God. That's an example of where I read that the way an attorney would read, because the way my mind works is it's just, I'm reading it from that perspective. So when I saw that, it didn't alarm me. To me, that was so normal, right? Because it's like, it wouldn't, a defense attorney wouldn't say anything else, right? You know what I mean? Like that's normal. Because it didn't name a person, right? It was like whether it was Bryan Kohberger, or whether it was an alien, or whether it was Santa Claus, or whether it was whatever, something only gets somewhere if somebody puts it there, right? You see what I mean? Like logically, right? Like something, you know, and so that's like a factual thing, right? But of course, it would be said knowing that lunatics could take it and run with it. And that's what I saw. I saw people like, oh my God, they're saying he was framed because the placing of and I'm like, oh my God. Like, and again, this is normal languaging from a defense attorney, because they're not gonna, it's a way, you can say the same thing many ways, right? That's the point. And you can look at a sentence from the state and you can look at a sentence from the defense, and they might be mostly the same or the majority of the same. And there might just be one word that's different, but then you could interpret it, the overall meaning completely differently. Right. And so, anyway, it's just. Right. Exactly. No matter what, someone placed it there, BK or another. Yep. It was implied. Yep. It was implied. And that's why I thought of it, right? How they were all on the same track. Just like the way stalking was intentionally implied by the state. Yep. That's exactly why I thought of that, right? Because it's very similar. I mean, another example kind of similar too is like the whole thing when she said he was innocent, Bryan is innocent. And then I got a lot of people asking me about that, like, questions about it, like, and it's like every defense attorney says that about their client, that you have to, it's your job. You can't say that, like, I mean, and even if a person gets convicted, and the defense attorney speaks out after the fact, they're still not going to ever say their client did the thing. They're going to say, you guys know, they're going to say something like, we thought we had a good shot and like, we've got some issues on appeal, whatever. Right. But they're not ever going to say their client did the thing. And the only exceptions to that would be something like where it's like, an NGI thing, or like, maybe self-defense where in other words, where the person doing the thing is part of the defense, right? And that's, but other than that, like anyway, it's just funny. And did she say I believe? I don't remember specifically. If she said I believe or not. I mean, you're right, that is different. But I trust you. If you think that's what she said, I believe you. Speaking of that, I believe you if you say that's what she said. I just can't remember specifically if she's used those words. No, I mean, that's absolutely true. That is absolutely true, for sure. Okay, we firmly believe. It is definitely a stronger assertion. It is definitely a stronger assertion. I agree with you, for sure. But having said that, I still don't think it is impossible that they were just, that Miss Mathis was just getting impassioned, and was passionate. And I remember that it was being argued at a really crucial time too, wasn't it? And there was something on the line. I can't remember what it was. There was something on the line. And it just seems like to me, it didn't strike me as, like, when I heard that, I didn't even notice it, right? It just seemed normal, like when you're passionate and you're, I don't know. But I do agree. That is stronger languaging than what you would normally hear, for sure. But you can also think too, right? If they really want to try to persuade a judge on an important issue, you can see how that would, again, be more persuasive than going with the standard fare, right? In a way, you could almost say too that it would have been even more of a stronger indication if, instead of saying I believe or we believe, if it was just like, if they had just said Bryan is innocent, that would actually take the subjective factor out. Because again, in a way, you can almost say, well, like, there is defense attorneys, they're supposed to believe. Again, usually it's in believing in, presumption of innocence, right? But still, it's like for her to say, we believe he's innocent, it would almost be stronger in a way to be like, everyone, like, it doesn't matter who you are. It's just, it is what it is. It is what it is. Take belief out of it, right? In a way. Okay. So you just found it. So Your Honor, Bryan. Oh, it was said by Ann Taylor. Okay. Bryan is innocent. Okay. Yeah. And again, though, I mean, you can probably hear from what I'm saying that this is where the law brain, because the whole part about law, right? You have to be able to see everything both ways. A lawyer, says it all the time, right? And it's actually required, right? Like, and actually some of the things. So when I was doing my paralegal certificate, one of the things that you had to do, and it's the same thing if you go and you become a lawyer, you have to, I was given, we had to do it a lot, but an example of like, it would be, based on real life, but here's a case, right? This happened, blah, blah, and they give you they outline, somebody committed this crime, whatever it is, right? And my job for these assignments was to find, case law, supporting it, that they met the elements of the crime, right? And to actually write, like, I had to actually write, I had to write a lot of things, but like the appellate briefs were probably the biggest ones. And so argue it, right? So find the case law, go through the whole thing, go through the analysis, and argue, right? That position. And then for the exact same, everything the same, right? All the same set of facts, same thing. And then do it the opposite, right? So find case law that says this is not correct and this is wrong, and then argue, and then write a whole thing, argue against it. I mean, and that is what you do. You have to see both sides, and it is, and so I'm just, as I'm talking, I'm like, I see myself doing this when I think things through, is constantly seeing both angles of it. So that being said, the thing that I was just thinking, right? Even though, right, like, so with Your Honor, Bryan is innocent, I could also see that being said because he is innocent until he's proven guilty. So my brain was just like arguing with myself over the different ways this could be interpreted, right? Again, or rather the way it could be said and be truthful and also could be interpreted, knowing that it could be interpreted differently by the listener, the public, if that makes sense. Oh, that's fun. I didn't know you participated in mock trial. That's fun. And it definitely is. Yeah. I mean, and it's also really required too. Like if you're, when you're writing a motion, right, you're supposed to provide the case law that also takes the opposite position. So now, having said that, some courts don't always point it out if that's not done, but it just depends on, of course, the court, as in the court, the judge, right? But you're supposed to provide the opposing case law as well for any motion when you cite your supporting case law to support the case law that opposes it as well. But sometimes you do see it though, but it's supposed to be really always there. So. Oh, that's cool, Heather. Like a criminal justice program, or? Yeah, well, I figured if you were an attorney, I feel like I would know that by now. But yeah, I mean, that is something to think about, right? Like, I mean, when you think about the presumption of innocence, right? And if you're a defense attorney and you really take it to the next level to where it just becomes a part of your, your psyche, you could say that, right? You could say somebody's innocent. Like, the other thing is this. As a defense attorney, if you listen to any of the great defense attorneys on LawTube, right, they'll all say the same thing. When people will ask them questions like about if they think a person did it, or what happens if they have a client and they know the client did it, they'll all say the same thing. They don't even ever think about whether the person did the thing or not. And I think part of that is because to be a good defense attorney, you really have to train your brain to not go there, unless for some reason it's necessary, but that would be the more rare case. But you would have to train your brain not to go there, because here's why, right? What you would rather do if you're a good defense attorney is train your brain to believe so strongly in the presumption of innocence that the only thing you can think, unless and until there's a guilty verdict, is the person is innocent. That is the only thing you can even think. So there's that, right? Like, if that makes sense. It's like taking it to that next level of like beyond like the presumption of innocence, right? And all that. But like, it's like you can do that with anything, right? And people can do it in ways that are bad too. It's like when you really believe in something so much that it kind of starts to transform over time into, I don't know if that makes any sense, but and in this case, I would say it's a good thing, because again, it's like, that's what you want. If you're a criminal defendant, right? You want your defense attorney to be that defense attorney who literally can't think things any other, like they couldn't, because there's some defense attorneys who like will probably say they couldn't go back to being a prosecutor, right? Because the way that they perceive things has, their psyche is now different. Bob Mott is an example of that, because he'll even say, what was it he said at one time? Like, again, I think it was on that podcast lawyer, but he was like, his blood is like literally only defense attorney or something like that. I can't remember exactly. Or it's like his DNA is D for defense attorney, something like that. Funny. Like, but that's the type of defense attorney you would want. You know what I mean? They can't go back. They can't go back to thinking of it as a prosecutor. So, but y'all, I'm going to, I think, call it a night because I'm still getting over the laryngitis. My voice is starting to feel like it's getting a little bit tired. Although, I mean, it's way better than it was, obviously, but still not quite back to normal. So, but yes. So, and I'm glad too, we remembered, I'm going to make that follow-up live stream on the trash at some point too. So we will continue that discussion. But I think tomorrow, what are we doing tomorrow? I think tomorrow we're doing Casey Anthony. And I think maybe also Murdaugh. I think I have 2 streams scheduled for tomorrow. But anyway, welcome again to everyone who's new. And thanks, whether you're new or not, we love the Scroll Crew. Thanks everyone for being here. And if you are new, I just let everybody know I have playlists on my channel for all the cases that currently I'm covering and all the ones I have covered. And I always do really detailed timestamps for every live stream. So for anyone who's on Replay Crew too. I just appreciate everybody being here and contributing and keeping an open mind and being objective, even when it's difficult, and being a good human. So yeah, but other than that, y'all, I hope to see everybody soon. Love y'all and see you guys next time.